Yes. Welcome, everyone. Welcome to the Moorish Investigative Research Committee. The Moorish Investigative Research Committee, Session 6. Session 6, September 14th, 2024, 3:10 p.m. Eastern Standard Time. The day's topic is Using Legal Principles to Draft Motions and Pleadings, Part 2. Using Legal Principles to Draft Motions and Pleadings, Part 2. So we definitely will continue with Michael Long's base case, and also give the outcome. And so we're gonna you can move to the next slide, Amanda. So welcome everyone joining the Moorish Investigative and Research Committee. We're into our 4th month. It's going to be, as I said before, it's going to be 6 months of education. I'm muted. All right. So looking forward. Yes, so we see here the Moorish Investigative and Research Committee, Session 6, September 14th, 2024 at 3 p.m. Eastern Standard Time. Sponsors: United Tribe of Sovereign Moors and the Moroccan Post School of Government and International Law. Keng Bey, Committee Chair. Abdullah Il Talib Mosi Bey, Committee Advisor. Shem Malachi Bey, Committee Advisor. Amanda Siegel, Committee Secretary. And Okono Sankofa Bey, Committee Co-Secretary. Title: Using Legal Principles to Draft Motions and Pleadings, Part 2. All right, we're going to have a 10 to 15 minute presentation by one of the committee members. Fact-finding tool lesson from one of the committee members, Israel Bey. Israel put together this lesson last week. He posted it on his Facebook page, and it was he tagged me, and I was highly impressed. So I thought it would be great as a way to inspire others to do the same. So that he'll have the will for the next 10 to 15 minutes in doing his presentation on fact-finding tool lesson. All right, so Israel, you have the will. You're muted, Israel.
All right, is it going to come up on the screen?
Yes, it's going to come up on the screen. Yes, she has the slides.
All right, here it goes. So fact-finding tools.
She's going to have the next slide up. So this is Israel's presentation that he put together, posted on his Facebook page.
So, yes, fact-finding tools are indeed a principle in law. They are essential in various legal processes, including litigation, arbitration, and regulatory investigations. Here are some key points about the role of fact-finding tools in law.
I'm sorry. Yeah, bear with me. It's just taking, it's not letting me seamlessly.
All right, as we're waiting for the next slide to come up, this is Brother Israel. Israel, one of the committee members, he put together just a fact-finding tool lesson. He posted it on his Facebook page. And this is a way in which we can inspire other committee members and others who are not committee members, as this has been shared on the Moroccan Post Media YouTube page. It's we have over 560 views on session 5, which was the last session, or over 500 views on session 4, which is part 1 of the using legal principles to draft motion and pleadings. All right, Israel?
All right. So number 1, evidence gathering. Fact-finding tools are used to gather evidence, which can include documents, witness testimony, physical evidence, and expert opinions. This is crucial for building a case and supporting legal arguments. Number 2, discovery process. In litigation, the discovery process involves fact-finding tools such as interrogations, depositions, requests for production of documents, and requests for admissions. These tools help parties.
I just want to, that's interrogatory. Okay.
Indeed. So I'll read it again.
You read that, we read that as well?
Yeah, I'll read it again. So discovery process. In litigation, the discovery process involves fact-finding tools such as interrogations, depositions, requests for production of documents, and requests for admissions. These tools help parties obtain relevant information from each other. Number 3, due diligence. In transactions such as mergers and acquisitions, fact-finding tools are used for due diligence to assess the legal, financial, and operational aspects of the entities involved. Number 4, investigations. Regulatory and internal investigations use fact-finding tools to uncover facts related to potential violations of laws, regulations, or company policies. This can involve audits, interviews, and document reviews. Number 5, alternative resolution. In arbitration or mediation, fact-finding tools help neutrals, arbitrators, and mediators understand the issue in dispute and the evidence presented by the parties. Number 6, public inquiries and commissions. Fact-finding is also a key element in inquiries and commissions, where investigators collect and analyze evidence to understand complex issues and make recommendations. Fact-finding tools are fundamental in ensuring that legal decisions are based on accurate and comprehensive information.
I think that's it right there, Israel.
Yeah, that's the last slide.
All right, so man, great job, brother.
So could we discuss some of the stuff that he went over?
Yes,
yeah.
I want to break down certain points within each topic, because there's certain things that need to be emphasized, like stuff that I was saying when we looking at this, understanding how these fact-finding tools help the litigation to make certain determinations about certain facts based upon information, right? Amanda, you still there? You still with us? Could we go over each section, Amanda? I think that's the last slide. Okay, let's go to the next one. Okay, when they talk about rules of evidence, right? When we talk about principles of law, this is integrated for the purpose of fairness. You got to remember, fact-finding tools is used in an equitable sense to give both parties equity, because it's about making both parties whole. So you need to understand why these are important. So what you want to do closing out the show, when you go into court, so if you have to go through a fact finding, I want you to understand this. The reason why Mike was so successful, because it didn't need to go to trial, because it was too many facts that pointed out, and it was already basically the court can make a summary or a judgment based on the facts that was identified, in which the prosecutor couldn't defend against. So it was already, so if you understand in civil cases, because it's all civil in nature anyway, what you want to do, you want to collaterally attack the jurisdiction, because due process is a requisite that they have to follow. They cannot move. So when I hit the court with a due process issue, they can't move. They can't move forward. They can't do nothing until the due process issues has been resolved. And you will see how we and Mike discuss certain things and how the case was pretty much frozen in its track based on legal understanding these legal principles. Next slide, Amanda. Evidence gathering, right? When they talk about documentations, right? We talk about contracts. So a lot of you guys, when you talk about trust and when you talk about your cars and you talk about all of these different things, a lot of you don't have contracts. You don't have lease agreements, right? A lot of you guys are driving around in an automobile, right, that's registered, to you, that give the state jurisdiction, but it shouldn't even be that way, because if you knew how to contract, you would contract the car, right? And you will be identified through an entity that says it's going to cover the insurance, making you non-liable. When we talk about this is levels to this, when we're going to get into the contract court case, contract law course, I'm going to break down certain things about lease agreements, right? Leasing, licensing, all of these different things, making these arrangements. So when you go into court, even if you're going to court under a traffic ticket, for example, the company, if you got a traffic ticket, the company will be responsible for the ticket, not you, as long as you didn't injure nobody. So there's certain things that you will have to understand when we get into that. So witness testimony. So you have, even with contracts, right, affidavits, and a lot of y'all don't know how to utilize affidavits to its fullest maximum potential. So, for example, using a notary to attest and testify through a notary attestation in creating a contract, a situation where now the notary is not only acknowledging the document, but attesting to the facts. Then getting it authenticated on the state and federal level. These are aspects of discovery and aspects of evidencing, using evidence as exhibits through this to make certain conclusions of law. Based on your experience and knowledge, like I don't have to think about it. I do this in my sleep. Physical evidence, that's just things that you can take pictures of, things that you can bring to court, certain things, certain items, right? And then you have expert testimony. Now, what you have to understand about the expert testimony, the person has to be qualified and have enough experience in there. So what you have to do is verify these people's credentials. These people got to be accredited by a college or have experience, work experience, and then they have to verify their experience. You don't just get to say, I'm an expert. You bring somebody in, your brother-in-law is an auto mechanic. Okay, what kind of experience? Who do he work for? What kind of evidence that can prove that he has this type of education and knowledge that can solidify his testimony on this particular subject? What is his credentials? Could he bring in a job that he says he's been doing this, or could he have various people testify that he's been doing this for a very long time? That do we have information where he has either a college degree, he has years of experience, and that he can verify by his employer, or he has his own business, which you can submit his his EIN number and his business location that he's been in business, his website. All of these different things is very critical to being able to be an expert witness. You can't just walk in off the street and say, I've been this for this long. Where's your credentials or the backing that support? What is the supporting documents or evidence that can support your position as an expert? That's very critical, because a lot of people mess that up. They botch it. So that's very critical in understanding and building your case. The next slide, Amanda. Okay, so when we're talking about in the litigation, talking about using different forms of discovery. So I wanted to talk, it says interrogations. So you can use even in a criminal matter, you can use what they call interrogatories. It comes from the word interrogation, but they're interrogatories. Under certain criminal rules, you can use that as questions to help expedite the case under a criminal rule, because the civil rules give birth to the criminal rules, because it's all civil in nature anyway. So you have to understand these things. So you can use the civil rules in traffic and criminal cases, and you can use the criminal rules in traffic cases also. But you have to look at how your state have the rules formulated. My state, you can use the civil rules in criminal matters when it's based on certain things that you need to know. So we're going to talk about those interrogatories. Admissions, I want you to understand what admissions is. Admissions is certain testimonies or certain things, like you give a question, you have interrogatories and admissions where you use those or questions to have the other party to either admit or deny the facts. Once those admissions has been determined, once you do all of that, using interrogatories and admissions, and now the court can look at those facts and make a certain sound determination, and they can make a ruling based on utilizing this technique. This is a very skilled process. I use interrogatories and admissions all the time in criminal and civil cases, and even traffic cases. A lot of time they would try to object, but I will point to the rule according to the criminal rule, even the traffic rule that give birth to the civil rule, because the civil rule give birth to all of it. So I just wanted y'all to understand, interrogatories and admissions is a very good technique. I use those a lot. Okay, next slide, Amanda. Due diligence. I want y'all to understand that motion pleading and everything is time sensitive. It's called time computation. You must be on time. So if you read the rule and it tells you have to file this 7 days before trial, 7 days before the next hearing, 10 days before the next hearing, right? Then you must perform that, because if you're out of compliance, you must ask the court for an extension of time. And you must show good cause, reason why you are out of time. You're not filing the motions within the scope. So you must understand this, to be able to operate the court. I just been doing this a long time, so I know how to do this. Next slide, please. So investigation. So when you utilize these fact-finding tools, you just perform an investigative. So a lot of you guys, I need you to think about it. Pre-investigative work, Freedom of Information Act, Open Information Act. Freedom of Information Act goes to the federal government. Open information requests go to the state. Gathering evidence on particular subject matter, statutes, or whatever, policies, having it noted, even if they don't answer, having it, a record of it, could also be very powerful when presenting your claim, because the state has a duty to respond to you, and they fail to do that. So it's impossible for you, based on certain questions that you ask them, based on you do a freedom of information request. You can now use that and say, I already answered the state already. I asked the state this question.
Keng is frozen. So he's here. We're looking at investigation. This is a presentation that Brother Israel presented a few minutes ago. He posted it last week on his Facebook page, and Keng is just giving us more insight into the various topics dealing with the fact-finding tools. Welcome those who are joining us now to the 6th session of the Moorish Investigative Research Committee, September 14th, 2024. Now, this is today's topic is using legal principles to draft motions and pleadings, part 2. Part 1, all 5 sessions are on the Moroccan Post Media YouTube page, including part 4. Part 4 has over 500 views. So this is part 2 of Michael's case, using legal principles to draft Michael Longbay's case, using legal principles to draft motions and pleadings.
I apologize.
All right, so welcome. So welcome those who just joined us. So Keng is back. All right, and continue, Keng.
So when we talk about pre-investigative measures, using those types of strategies, freedom of information requests, open information requests to get evidence gathering, showing that the state is being biased, showing that you reached out to certain departments, certain institutions within the government, and they failed to give you a timely response without just cause. Certain questions that you may be regarding, a lot of y'all like to talk about nationality or whatever, certain things. This is very crucial. So when you build upon your case, you can go to case and you can say, well, hold up, wait a minute. Here's evidence. I asked certain states about certain things regarding to certain subject matters in which the state never respond. Because certain things I have some questions because the statute has some vagueness to it. And there's certain things that's going on.
This is a very good presentation. I want to thank Brother Israel for presenting this to us and sharing it on his Facebook page. Last week he tagged me, and so Keng is giving us a extensive overview of each of the slides.
So I'm just giving you critical points in which you can learn how to utilize information, right? So let's go to the next slide. Arbitration and mediation and fact-finding tools help. So This is what you have to do. When I talk about your numbering, right? You have to set your case up for the judge to be able to look at the motion, have it numbered, have the exhibits, have it all aligned where it's simple for the judge to read it. He's not going to put your case together. If you got motions, you don't have them numbered, you don't have the exhibits identifiable, you don't have the affidavit number where he can go to the line per line in which you're making your brief and you're referencing points to certain exhibits and affidavit, the particular lines in which you're utilizing, he's not going to do it for you. So if you don't know how to put your pleadings, this is another technique that's missing. That's missing. Because you got to understand the prosecutor gonna have favor if he doesn't do it, because he's gonna argue it and he get to meet the judge outside of chambers. So when you lay the foundation very outright, where the judge can follow it, he can see everything is organized, everything is numbered, where everything that you argued and referenced, that he can go right to it based on that, it makes the job easy. This is why Mike was very successful. This is not a coincidence. This is based on techniques and experience. Let's continue. Public inquiries and commissions. That's what I was talking about, utilizing Freedom of Information Acts, open information, and other fact-finding tools to address the public. Because remember, these are public servants. They have duties, they have a certain expectation. They have to act in a certain amount of conduct, right? So you need to know the rules of judicial conduct along with these other rules and all the rules surrounding this case. What you need to understand is the rules are governed by the Supreme Court. They govern the conduct and the rules, how everybody's supposed to follow the rules. This is why when you go into making a constitutional question or making a question upon appeal to the Supreme Court about due process in the rules, they answer that's a due process question. And they have the duty, the Supreme Court has the duty to answer that question. They can't ignore it. So a lot of you guys' cases don't be heard in the Supreme Court because it's outside of the realm of the questioning that you have to present to the Supreme Court, because they have the duty to do what? Enforce due process, substantive and procedural due process. If it's not a question according to, if you're asking about statutory, the statute and all, that is outside of that. They don't have to answer that. That's why they give opinions and they make decisions. Opinions is based on things that they don't have the scope to make the ruling on. But if you give them something that they can sink their teeth in based on a constitutionality of the case, based on due process and the other things, they have a duty to abide you. These are just litigation techniques that most people miss. I've been doing this too long. Okay, Amanda, next slide. I think that was the last one after that. So these are fundamental. So, and once you understand this, it makes it just simple, family. I just wanted to go over this to give some more clarity. Abdullah, do you want to add anything to this, Abdullah?
Oh, no. Once again, I want to thank Brother Israel for presenting this to us and for sharing it on his Facebook page. You get a chance, Brother Israel, repost this on your Facebook page. Tag me, Keng, Quasi, Pacola, etc, etc, etc. All right?
I will. I got you.
So, this, Brother Israel, this was a good job. This is very important to know. So this is one of the steps. This is why I'm helping everyone educate themselves in this art form. so that we can better stop making mistakes, killing the misconceptions so we can win, right?
Yeah.
Okay,
All right,
I'm ready.
Matt.
Ready.
All right, so continuing. So we have an introduction and overview transcript from Michael Long Bay's last court appearance on August 20th, 2024. All right, so we're going to read the transcript, Amanda. We're going to bring up the transcript. Transcript from Michael Long Bay's case. Once again, welcome everyone. This is session 6, titled Using Legal Principles to Draft Motions and Pleadings, Part 2. Part 1, as well as the other 4 educational sessions, are on the Moroccan Post Media YouTube page. You are free to share it, post it on your Facebook, other social media platforms, or any of the classes. All right. We can have a reader. Let me have a reader. Other than Amanda. Jump right on in. The leaders of the day. These are future Moorish ambassadors, Moorish consul generals, Moorish consuls, Moorish vice consuls, Moorish short affairs, Moorish viziers, Moorish vice viziers. Right. Rise up. Next, what did Andrea Day say? Rise up.
In the county court of the 10th Judicial Circuit in and for Polk County, Florida, State of Florida, plaintiff versus Michael Long, defendant. Case number 2024 MM-005136. Hearing, August 20th, 2024. Attorneys, Curtis Griffin, Esquire for the state. Office,
Go down, Amanda, so he can read that. Office, yeah, so he can read everything. Go right there, yes.
Office of the Electronic Court Reporter, 863-534-4009. In the county court of the 10th Judicial Circuit in and for Polk County, Florida. Do I need to read this again?
Yes.
All right. Polk County, Florida. State of Florida, plaintiff versus Michael Long, defendant. Case number 2024 MM-005136. The above matter came on for a hearing the above matter came on for a hearing August 20th, 2024 at the Polk County Courthouse, Bartow, Polk County, Florida, before the Honorable Hope Patty, County Judge. Patty, the County Judge. All right. So appearances were Curtis Griffin, Esquire, for the state. Thereupon, the following proceedings were had and taken. The court, State of Florida versus Michael Long, 24 MM-5136. Mr. Long is present and approaching. All right. Mr. Long, are you ready to set your case for trial? The defendant, I am not. I filed a number of motions, and I also filed a motion to withdraw my, I'm thinking it's supposed to be plea.
Yeah, supposed to be plea.
All right, plea. The court, you haven't entered a plea other than your plea of not guilty. The defendant, yeah, subsequently, but when I was here last time, the court had taken the liberty to enter a plea in for me. The court, correct. That's the way we do things. The defendant and the court, when you want to move forward, you enter a plea of not guilty. The defendant. So what I did was I objected, and I filed a motion to withdraw that plea based on the Florida criminal rules. And I also filed a judicial notice at the hearing. I also filed a motion for discovery pursuant to Brady. The court, okay, did you send a copy? None of these motions have been sent to my office. Did you send any of these motions to the state? The defendant, I did. I actually came up here, I want to say it was close to 2 weeks ago. I apologize. I got something in my eye. The court, but you didn't send them to my office. The defendant, I did. I electronically served everybody. The court, okay, well, my office has not received anything from you. The defendant. So on the maybe I can ask the state, as I'm sure that I served it on the state. The state had a copy of the judicial notice. What else? Motion. What else? Motion to dismiss. My motion to withdraw my plea. A number of affidavits from other individuals. I attempted to bring them to the prosecution maybe 2 weeks ago, hand delivered, but I couldn't get anybody. But when I filed them, they were electronically filed, and everybody was served properly. Oh, shit. Maybe perhaps you could ask the state. The court. I don't need to ask him. I don't need to ask him anything. I mean, I see that you filed them with the clerk's office, but you didn't send to my office. So if you don't send things directly to my office, then you're not going to get a hearing date because that's how it gets set. The defendant, and I and the court. So, all right, the defendant. I thought that on the electronic filing, it served all parties. There was an option to serve all parties. The court, well, it didn't serve me. The defendant, okay. The court, we're going to go ahead and set your motions down for hearing. The defendant, now I do have a copy, a couple copies if you wish to. The court, I made a note. I'll make sure they all get printed out. The defendant, okay. The court, can you tell me what I have set on the 23rd of August? The defendant, and then next, Your Honor, I am slammed with this month. I mean, when I say slammed, I mean I'm very extremely busy. The court, so September is not a good month for you. I mean, October, August. The defendant, terrible. The court, August is not a good month for you. The defendant, August or September is really not. The court, well, we are not going out past September, so we're going to have a hearing in September. The defendant, well, I could have tell you what my calendar may look like. The court, sir, I understand what I know your calendar may be busy. My calendar is busy too, but we're not setting this case out further than the defendant. Well, but the court and in order to get it to move, period, you're gonna have to waive your right to a speedy trial. So if you're not willing to do that, then I'm not gonna set it on the trial calendar today. The defendant, well, just to let you know, Your Honor, my availability. I've got contracts prior to this case ever happening that take precedent in my life. The court, well, they don't take precedent in my life. This case is yours. It should be your important thing because you can go to jail. The defendant, well, the court. So one more time, Mr. Long, you have to waive your right to speedy trial in order to even get a hearing date. Are you willing to do that? The defendant, I'm not willing to waive my rights. The court, all right. Then what we're going to do is I'm going to go ahead and set this down for trial. I'm going to set it for mandatory docketing on September the 11th. The defendant, you know, Section 10, the court, with a jury trial to be taking place the week. The bailiff, don't interrupt. The court of September the 16th. The defendant, it's you're interrupting me. The court, if you wish to have your motions heard, you can contact my office via email. The defendant, can you say it on the record? The court, stop talking, sir. The defendant, he's talking to me. The bailiff, stop talking. The court, okay, just stop talking. Look at me and listen to me. The defendant, he's threatening me. The court, he's not threatening you. The defendant, in your courtroom, the court, he's not threatening you. It's his. So the defendant, he did it last time. The court, be quiet. It is his job to maintain security in this courtroom. Be quiet when I'm speaking to you. Do you understand? The defendant, do I have the floor next? The court, no, you do not. You will listen to what I say, and then you will exit this courtroom. The defendant, I do not understand. The court, well, then I can't help you. I can't help that you don't have a brain to understand what I'm saying. The defendant, that's just stupid. The court, your case is going to be set for mandatory docketing on September the 11th at 8:30. The defendant, I was kidnapped. The court, with a jury trial to take place the week of September 16th. Stop talking. The defendant, I was kidnapped. The court, stop talking. The defendant, it's my right to talk. The court, stop. No, it's not your right to talk. Stop talking. The defendant, so is this a constitutional court? The court, if you wish to have a hearing on the motions that you have filed, you can contact my office via email and get a hearing date. Do you understand? The defendant, I do not like being threatened in this court. The court, step out, sir. Step out, sir. Get your paperwork and step out. Thank you. The bailiff, step over. Have a seat. The defendant, I heard her say it. The bailiff, okay, and I'm telling you again. The defendant, I'm not supposed to have a seat. Hearing concluded.
Amanda, you can pull up the main document, the main write-up.
I want to go over that a little bit, Abdullah.
Yeah, we will. That's what I'm saying. That's what we're gonna do. No, not this pleading. The main part. Go back to the main structure. Not any of the motions. What we left from. That has the heading. Yes, right here. There we go. All right. So introduction and overview. Transcripts from Michael Long's last court appearance on August 20th, 2024. We just read that. Israel just read that. All right, here we go. All right, here we go, King. How was Michael Long Bay's? How was Michael Long's Bay in error in his action of going back and forth with the judge? Once again, how was Michael Long Bay in error in his action of going back and forth with the judge?
Okay, we got to talk about each party position. What is the judge's role? What is the prosecutor role? And what is you as the defendant? What is your role?
You know what? I have that down below, King. I thought you want to do that first, then. You want so we just go further down, Amanda. Then we already have that. Just go.
Did you want me to? Because you wanted me to answer that, or did you?
Yeah, I wanted you to answer that first. Yes, that's the question. But I have that. I have the bullet points for each role. I have the bullet points for each role.
Okay.
So what do you? So let's go back up, Amanda. All right. So let's go. So what was Michael Long Bay in error? How was Michael Long Bay in error in his action of going back and forth with the judge? Michael argued with the judge, who is a neutral party. Note, understanding the operation of law on how to perfect a claim will eliminate the misconception with debating back and forth with the judge. What does Michael Long Bay's action of going back and forth with the judge represent? What it represents is that the defendant may lack knowledge of the role of each party, prosecutor, judge, and defendant. So you want to do that now? Do you want to? So we go down, Amanda. We have each one of them. All right, here we go. The role of the judge, prosecutor, defendant, the perfection of due process. Can we have a reader? Other than Israel, other than Amanda. Step right on up. We have a reader. Future leaders, Moorish consuls, Moorish vice consuls, Moorish emirs, future Moorish emirs, Moorish wazirs, vice consuls, charge d'affaires. Rise up and then rise up. Future leaders. No reader.
I'll read the roles of the judge, prosecutor, and defendant, the perfection of due process. Rule of law is the primary legal principle. Fairness, accountability, accessibility, equality, and no arbitrariness. The role of the judge as a referee. The judge cannot present a claim on any party's behalf. The judge cannot argue a legal defense. The only role of the judge is to uphold the following: the Constitution, the procedures, and the rules. The judge must only be impartial and fair to both sides, upholding the rule of law. The role of the prosecutor: to seek justice within the bounds of the law, not merely to convict. Prosecutor's execution of perfection of claim. 1. The prosecutor must perfect service of process by serving the defendant properly on his or her person or his or her known address. 2, after perfection process, the prosecutor must perfect his or her claim by ensuring that all the facts are present in the substantive language of the statute. 3, the prosecutor must adhere to his or her constitutional oath. 4, the prosecutor can present his or her case to the court. The role of the defendant. The defendant is responsible for knowing his or her rights and the role of each party, the prosecutor, judge, and defendant. 2, the defendant, once upon knowing his or her rights, can protect and preserve the rights that he or she has. 3, the defendant is responsible for making his or her legal defense by knowing the following: knowing when to strike statements from the record, knowing when to suppress evidence, knowing when to object, plain error for appeal, making sure the court is preserving the record for appeal purpose by filing the proper motion pleadings, and by knowing the principles of law.
Abdullah,
go back up. Go back up, Amanda.
You did a great job, Abdullah, to remember all this stuff that was coming out of my mouth. You did a great job, brother. I didn't know you remember that. You kept that in your head. I was talking, and you wrote that down, got it together, brother. I mean, that's a great job. I commend that. Abdullah, you did a real good job, because I was just talking.
All right, so we're going to open up for Keng. I want you. So once again, how was Michael Lombay in error in his action of going back and forth with the judge?
So what you guys got to understand, based on what was read, the judge is not he's not invoking the jurisdiction. He's not bringing the claim. So you wasting your time going back and forth with the judge. The judge only thing is to know the rules and make sure that fairness is given to both parties. It's not to go back and forth with the judge. It's not about the judge challenging. Challenging jurisdiction is based on you talking to the prosecutor. What jurisdiction is he invoking? He has to know what he's doing. He's bringing the claim to the court. The court got to make a decision. Just like if you file a claim, the court going to tell you, oh, no, you're in the wrong jurisdiction. If you file a criminal case in the bankruptcy court, they're going to tell you they can't hear it. It's mute. Same thing with any criminal case or any other court. It only can hear particular certain topics of law or subject matter based on the assignment of the jurisdiction that they're in control over. So if you don't press the prosecutor, for example, the judge, you might ask the judge might say, this is statutory court. The judge ain't invoking the jurisdiction. What the judge saying don't matter. Why? Because he's not bringing a claim. You're supposed to say, okay, prosecutor, do you agree with the judge? That's how you're supposed to. Now, he must identify the jurisdiction. And if he say, yeah, this is statutory court, judge, I would like to move and dismiss this case for lack of subject matter jurisdiction. Lack of jurisdiction to move with prejudice. Why? Because there's no such thing as a statutory jurisdiction. Not identified by the Constitution. If it's identified in any other category of subject of law, the four primary jurisdictions got to be first identified first. I want to know the constitutionality of this case based on the constitutional jurisdiction that's granted.
Give the 4 jurisdictions in the Constitution, King.
There's common law, equity, admiralty, and maritime. Those are the only 4 that's constitutionally sanctioned or identified. Those are the only ones that's granted. So the primary jurisdiction or the constitutional jurisdictions first got to be identified first. Failure to do so, the court is locked. Listen, they can't have jurisdiction until they follow requisites. I can withdraw my plea. I can say the court cannot move until the constitutional requisite or the Constitution, my due process issues have been, having these due process rights. I have these rights and I'm not waiving them until the prosecution perfect such action in his requisites by understanding the due process based on the constitutional requisites required. There is no jurisdiction can be had until this is perfected. I ain't got nothing else to say. Let the judge argue. Your job is not to argue with the judge. It's not, don't go back and forth. Don't let the judge say what they're going to say. You can object. Only thing you can do is object, strike, have the judge repeat or anything like that. But you trying to argue back and forth with the judge, no. You're arguing with the prosecutor, not the judge. If the judge is making errors on the record, making errors, abusing his discretion, that's an issue for the appealing court. That is an issue for the appealing court to deal, then do what? Handle that judge that's abusing this authority. The prosecutor don't handle that. You arguing with the judge is not going to handle that. You have to understand these legal techniques to be able to have legal standing because you're creating a record for appeal. So what do you want to do? So even a lot of times I don't let them go to appeal. I don't let them go to trial. What do? I file a motion. I do other things. I file stays. But we're going to get into that as we move along.
Do we have any questions? Questions or comments? Questions or comments? Any questions? Comments? Criticism? Add that in there. Everybody, everybody understands? Everybody understands the role of the prosecutor, the judge, the roles of the prosecutor, judge, and defendant? Brother Noble?
Yeah, this is Noble Brunner Miguel L. Bay. I just want to say this is good stuff. keep on doing what y'all doing. Peace and love.
So where does this come from, King, of conscious Moors going back and forth with the judge? Like, where did that, because we see that a lot among conscious Moors of going back and forth with the judge. Like, where this is prevalent in this Moorish movement.
Misconcepts, from following leaders that have taught these misconcepts to go back and argue with the judge and challenge the judge. The judge is neutral. He's a neutral party. He's not even involved in the case, other than being a arbitrator. That's it. He's neutral. He or she is neutral. They're just a referee. They're there to keep all parties following in alignment with the rules. They're not actually a party to the case.
So just like a basketball, just like a referee in basketball, just like an umpire in baseball. So think of a referee in basketball. So we have this two teams, the 76ers and the Lakers are playing. 76ers and Lakers are playing. There's three referees on the court. The referees are not part of the Sixers. They're neither part of the 76ers or neither part of the Lakers. The referees are a neutral party. All right? So the same with the judge. The judge is a referee or umpire. So the concept of knowing the judge's role was not known by conscious Moors, because they not viewing the judge as a referee. They're not viewing the judge as an umpire. So we want to make sure that this concept is solid. It's going to take some time. We understand that. When you've been groomed into misconception for years, this is not some overnight, but we got to prop the principle as we're preparing the Moors to run Moorish government, preparing the Moors to run Moorish government and teaching legal principles. So the focus is on the legal principles.
You must know the legal principles. If you will never win your case, you might fluke up and accidentally, and the prosecutor might. You might, but I'm telling you, if you don't know these legal principles, you're not going to be able to win your case. Because you ain't going to know or be able to identify what's going on in the courtroom. Because you're ignorant to the principles. You don't know how to go about dealing with your case properly. It seems like in this Moorish movement, we want to skip over everything and go straight into government, but you're not even going to know how to run government. The world is going to look at us, ain't nobody going to want to deal with us. We're going to look like a rogue country that's doing a dictatorship, trying to bully our way into everything that's going on, while the rest of the world is created a system of law in which they're following, based on understanding the principles and everything that they engineer and they set up for a particular reason. Go ahead, my brother. Ask a question. I see a Noble Burners.
Yeah.
Ask a question.
Yeah. Again, Noble Burner Sir Miguel El Bay. Whenever you go to a court case, always make sure that you have the magistrate's oath of office. It helps. And why are we calling them judges? Because they're not judges, they're magistrates. There hasn't been any judges since 1931.
Abdullah, do you want to address?
Now, let me address that, because we still, all right. We don't want to get away from the principle, though. We don't, all right. All right. We don't want to put the emphasis on whether they magistrates or judges. What is the role, though? Let's stay there. What is the role? Let's put the focus on that. What is the role of the defense? what are the roles of the defendant, magistrate, and or judge or prosecutor? Let's stay there. I want those who will be listening by the thousands later on to make that the focal point. What is the role of the magistrate and or judge, a referee? We don't want that point to get lost. A referee or umpire. That's the role. The judge and or magistrate has no skin in the game. Once again, the 76ers and the Lakers are playing. There's 3 referees on the court. The referees don't have a skin in the game as far as they're refereeing. They're neutral. They're neutral. So we want to make sure that that concept, we don't want the concept to get lost about what the role. All right. Let's look at Michael. Why was Michael an error? To stay there. What was Michael doing? We read Israel read the transcripts. Michael did not say one word to the prosecutor. We want y'all to go there. Please hear me, my brothers and sisters. I need y'all to say that. I need y'all to say that. I need y'all to identify the error. Michael Long Bay did not say one iota word to the prosecutor. We're not talking that. Like, why one of y'all didn't say that? Why? I mean, let's point that out. Why one of y'all didn't point that out? We got to point that out. All right, why didn't Michael? When these conscious Moors, they don't talk to the prosecutor. They don't say one word to the prosecutor. Back and forth with the judge. Back and forth with the referee. All right. Back and forth with the referee. 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 Back and forth. Back and forth. Back and forth with the referee. They don't say one word to the prosecutor. Why is that? Why is that? Keng already explained it. Misconceptions. Not knowing the roles of the defendant, judge, and prosecutor. We need to make this sound. This has to be clear. Not knowing the roles of the judge and or magistrate or prosecutor and defendant. Continue. Ken, you want to elaborate?
So it's 2 people. I'm gonna let both of them answer after I answer.
Oh yeah, that's that Phil question. I didn't see that. Thank you.
So Rod, so let me just say this. Knowing the roles is a crucial component, right? Because if the judge will steer you into a direction in which the prosecutor get a scapegoat, and they're going to move on with the case. You didn't make sure that the prosecutor perfected his claim. You didn't put the burden back on the prosecutor. He the one who has the burden of proof, of proving his claim, perfecting the service, making sure due process is followed. I mean, the judge makes sure due process is followed. He also got to perfect his service and process and everything that he needs to do in perfection his claim. But to go back and forth with the judge, all the judge there is to make sure that everybody adhere to the rule and give you due process. That's the only thing the judge got to do is give you due process. Mike never put the burden on the prosecutor. He allowed the judge to give the prosecutor relief because he didn't have to prove his burden. He had the burden of proof. Once Mike put in certain motions, he had to respond to those motions. The burden of proof is on the prosecutor. And that's what a lot of us do. We allow the trick of Houdini. The prosecutor get the trick of Houdini because the judge is throwing a distraction like in a magic trick, so that the prosecutor can escape. And now they're moving forward with the case, and you never put the burden back on the prosecutor. These are legal techniques that you got to know, family. You got to know this. People ask me, King, why you were so good? Because I knew this stuff backwards and forward. Abdullah, I don't read out of a book. When me and Abdullah talk, I'm not reading a book. I don't have nothing in front of me.
He spit from the dome, man. He spit from the dome.
And Abdullah be catching it. He right point by point. And I'm just talking. I'm not reading no book. I'm not talking about no jurisprudence book. This come from litigation experience. I have years and years and years and years and years and years and years of experience. 15 years. I should be good at it. Rashid L. Good question, brother. Got your hand raised. We're going to get back to you, Noble Burns. Give us 1 second.
Peace. Peace. Can y'all hear me? I have like a question, and I also wanted to make a statement.
Go ahead, brother. Go ahead. You got the floor.
Okay, all right. I just want to know if I was clearly being heard by everybody.
Yeah, you've been heard.
Okay, so my question is pertaining to as far as the system is concerned, how does it being de facto play into us being conscious enough to, go in and follow all of the rules of court, etc.?
Them being
All right, let me, can I address that, King? And then I want you to follow up. All right. Let me address that, and I want you to follow up. Once again, this is having a knowledge of the rules, the roles of the defendant, prosecutor, and judge and/or majesty in a Moorish government, Chinese government, French government, South African government, Iraqi government, German government. We got to do this, King. Got to do this. So let's do this. All right. So let's make it. Let's apply this universal. These are legal principles. All right. Having the knowledge. You're in France. French government. Having the knowledge of the roles of the defendant, prosecutor, or judge in the French government is vital. Chinese government, German government, South African government, Iraqi government is vital. This de facto, not de facto, gets away from the roles of the prosecutor, defendant, and judge and/or majesty. The judge and/or majesty is an umpire. You have to know that. All right. Once again, Michael did not say one word to the prosecutor. Didn't say one word to the prosecutor. De facto, left jump, hook jump, that had nothing to do with Michael saying a word to the prosecutor. We keep overlooking that. What does that have to do with Michael not saying anything to the prosecutor? I want somebody to answer that.
What case are we
What does the
referring
question?
to?
What does the question have to do with Michael not saying something to the prosecutor?
We're talking about the case we're going over.
The case we're going over, the transcripts. Like,
I just came in. That's why I didn't know.
all right, all right. He missed the, you gotta be, and then he has to go over the text, so then we have to move on then. Because we read the transcript, so we can move on. Because we read the transcript, so therefore you can't.
But
you can't.
That wasn't Brother Rashid L. asking.
Islam, Mr. Sheikh Red Cloud.
Okay, go ahead, brother.
Yeah, I came in late, but I came in on the transcript. And I have a similar case like that. I was in there as El Bay. And what I did was I was following a report on one of those complaints on the state trooper. And by me putting my number down, that number registered to my holy name, which led them to my contract name. What's the name of it right now? Well, anyway, so when I went to court, they dismissed all my El Bay cases. They called the state trooper in to identify me under my all caps. And I told them that wasn't me. That's not my name. They proceeded.
So let me stop you real quick, brother. Let me stop you real quick, because you're going to be long about a bunch of stuff. Did you create you a
That was about it.
I'm just saying, did you create, this is why I want to teach y'all about contract law. You could by just creating you a DBA. If you had a DBA doing business as, right, that your government name, you doing business as this person only under contract.
Yes.
Brought that into the court, they would have killed all of that.
I did. They dismissed the El Bay, but they came up with the Keith Ellison, my holy name, trade name.
Okay,
and called the officer and had pictures.
Listen to what I'm saying. So now you got to learn how to deal. If they're not going to honor that, right? You use that as an exhibit. You put an affidavit that said, okay, that such and such and such is go by El Bay, blah blah blah, based on his holy religious rights and whatever, blah blah blah. Stated in the affidavit, you stated in your memorandum, in your motion pleading, and then you got a number, you used the affidavit, please see line 7 such and such, this, that, and then had it as an exhibit. I do this all the time, man.
They had all that. They had all that.
So what happened there?
What happened was they called the state trooper and identified me as Keith Ellison.
Okay, that's
and it led back to my license.
But what I'm saying to you is, that's just a matter of the interpretation, and that could be something that could be dealt with the appellate court. The court got to address you by the name in which you're referred to do business in. So, that's not the issue. You got to remember that, right? That's not going to decide your fate. What name that you're using, that's not going to decide your fate. They're going to look at the evidence which you were charged with. Look at the substantive language. Look at, did the state meet the elements, and did you defend against those elements by understanding these principles and show that they ain't have a right to prosecute?
Right. Now, what I did, right, I had a fractured hip when I was in there, so they said I had so many days to appeal, which we don't appeal. But I didn't appeal because I was in so much pain. But where do I stand as far as trying to...
You asked for a stay due to the fact that you have an injury, and that you are, due to this injury, it is causing you too much pain to be able to execute your case. Go to the doctor, go get a doctor's note verifying that you got a hip injury and that you're on a pain medication and that you are incapacitated. Using motion pleadings, affidavits, and exhibits as a way of expressing and identifying what's going on with you so that you can ask the court to stay the hearing until further notice. Because now you have what they call excusable neglect and just cause for such action.
Facts.
Okay, I can still add that in now and do it over again.
Huh?
It's been over it's been over. I think they give you a certain amount of days to, you know, to get another hearing. So after that, they say that's it. I'm saying it might.
How many days?
Oh, it's been about almost 2 months now.
Okay, you might have to go back and file a motion at a time, asking the court for just cause. It's called a motion at a time. And then you're gonna ask based on excusable neglect due to the fact that you was under pain medication, and that you was under the pain medication and under this hip injury that caused you severe pain, and it impaired your ability to make a legal argument. And you got to go to the doctor, my brother.
So when the doctor give me that right there underneath there, which they was charging me under Keith Ellison.
You keep talking about Keith Ellison. I just gave you a remedy, brother. That's not going to seal your fate about your name. You making a big issue about the name. I'm talking about the action, not the name.
Okay,
they've been taught that, King. They've been taught that, King.
I'm making sure. I'm making sure that I'm asking this question and making sure what you said. So I'm saying I'm thinking one thing, then I walk away and not thinking what you're saying. I'm making sure I'm thinking what you're saying, because sometimes you give somebody directions and they go ahead and do something else. So I don't want to do that. You know? Okay, I'm clear on that. Yes, sir. All right.
We have one more question, and we can move on.
Brother Noble, go ahead.
Go ahead.
Yes. Noble Sir Miguel LP. Has anyone ever done an affidavit revocation of all contracts? Can you hear me?
You were breaking up. You were saying
you're breaking up.
Okay, I'll speak slower. Has anyone ever done an affidavit revocation of all contracts? It's called an affidavit revocation of all contracts.
Okay, so once again, so let me break this down again. Yeah, y'all got to see, this is what I'm talking about. This is what I'm talking about, these affidavits and this revocation of contracts. A lot of y'all do this, but then you still got a Social Security number. You're still getting all these benefits from the government, but you're talking about I revoked all of that. No, that ain't how it works. That ain't how it works. I listen, I've been doing this for a long time. Y'all put all these affidavits, I've been doing this for a long time. I've been litigating for years. Go ahead, brother. Go ahead.
Okay. Once you put in the affidavit revocation of all contracts, all the things that you've established that have been established in your I would say government name. For instance, some people might be afraid to do things like that because they're scared they're going to lose the Social Security check, or they're scared they're going to lose so on and so forth. Anything that you've earned in your lifetime, you cannot lose. So you revoke, if you put in an affidavit revocation of all contracts, you're not going to lose your Social Security. You're not going to lose your pension. You're not going to lose anything that you've earned under your government name, because that's yours. So there's no fear.
I'm gonna tell you once again,
to put in a revocation of all contracts.
That's a misconception based on contract. Let me
explain to you. Let me explain this, Abdullah. If I want to go to the Social Security office and withdraw from Social Security benefits, I got to do a SS5 form and physically a draw. An affidavit is a fact-finding tool. It doesn't do nothing but support your claim. That's all it does.
I was saying this, King. I'm going to say this point, that he made a claim. He made a claim that doing the affidavit on revocation of all contracts, you don't lose. Just follow me. Let me make this point. Just want to understand this. I'm just a critical thinker. That's all. Just a critical thinker. That you don't lose Social Security. You don't lose benefits. So but the Social Security is based on a contract, though. Just follow me, my brothers and sisters. you revoke it. Therefore, it's if you revoke it, how are you going to get it? Like, how are you going to get Social Security if it's all right? How is the Social Security gotten in the first place? Through a contract. If you revoke that and say, well, you're still going to get it if you revoke it. I'm just based on principles of contract. How did that work based on principles of contract? I'm asking the question based on the principles of contract.
Is what?
If it's an established, if the contract establishes it, if the contract establishes it, establishes the rights, the benefits, and it's revoked. All right, you have a treaty. Two nations have a treaty. The treaty is repealed. The treaty is now revoked. I mean, the rights are based in the treaty. The benefits, the trade agreement, the relationship is established by treaty. The treaty is now revoked. Both parties agreed to revoke the treaty. Meaning the benefits, meaning the treaty creates the benefits, the protections, the rights. If it's revoked, then what? That what was created by the treaty is no longer there. I'm just talking about basic concept of just understanding fundamental principle. It comes down to some fundamental principles. You can't revoke and then still have it. The contract creates it. I just talking about critical thinking. That's all. Just based on fundamental critical thinking and analysis.
The purpose of this lesson is to kill all these misconceptions. You're talking to somebody who's been doing this for a long time. I've been doing this too long. I know how to do things. I talked about Freedom of Information Acts. I talked about open information requests. If you're going to revoke some benefits, you got to then go through, it was established by a contract, and you got to end the contract. You can't put in an affidavit saying I'm revoking all that stuff don't work, man.
Peace.
I've been doing this too long. Yeah, go ahead, brother.
I just wanted to interject, and so we could go back around to the original conversation of the brother's court case, because Abdullah was touching on my question with the de facto part, and like you just mentioned. Now, how would they invoking the FARA to the not the defense, but to the prosecutorial party? How would invoking that play a part, or how does that play a part?
It's ARA. I don't know what that is.
They're requesting their what is that called? I know just the acronym FARA, and it stands for like that Foreign Registration Agreement Act that they have to operate here. That's what I was referring to.
All right, so let's focus. Let's state the focus is.
Let me stop doing
right.
it. That has nothing to do with the facts of the case. You finna go straight into arguing something. This is why we're getting into political legitimacy. The reason why they are not recognizing you as a Moor, because they know you have a vested interest. Once they say you're a Moor, you have a vested interest in treaties. So I need y'all to understand all this stuff that y'all doing, y'all wasting time and space. Arguing frivolous, they're gonna call this stuff frivolous. Because you don't have a treaty with them. You assuming that you got a treaty, but they recognizing you as black, Negro, color. They're not recognizing you as a Moor. So you ain't got no treaty, you ain't got no skin in the game, you can't challenge none of their authority on the international level. None. So y'all can keep playing this game and watch you keep losing. And two, that's why I linked up with Abdullah to go about doing this right. We need to get back though. All of these games that y'all gonna go into court and they gonna smash you and you gonna go to jail on simple stuff.
Can I say something, King? Because I got based on my 31 years of observation. I know who they're getting it from. I'm not going to say the person's name. I'm not going to say the person's name. Nobody says the name. No one says the name. I know where this is coming from. Conscious Moors have been indoctrinated into individual. I need to say this because into individual processes, not into facilitating and not restoring reversion to sovereignty, recovery of lost Moorish sovereignty. Conscious Moors don't know about that. You know, let me explain. 2 weeks ago, Brother Quasi on his class was I think 2 weeks ago. He had and he showed the Italian Constitution, the people of Italy. In the Italian Constitution, this is what Quasi was talking about. Let me put it in the context. The context in which Quasi was presenting was that the claim by conscious Moors, and I was one of them, 25 years. I was one of them. For 25 years, I taught thousands of conscious Moors that we, the people of the United States, refers to the Moors. I taught that for 25 years to thousands of conscious Moors. There are conscious Moors who are still teaching that. I no longer teach that. I have not taught that for 5.5 years. I no longer teach that. But there are conscious Moors who still teach that. Quasi, he made a point that it doesn't read Moors. It doesn't read we the people of Morocco or the people of Morocco. It doesn't read that. It says we the people of the United States. So what Quasi did was he showed as an exhibit the Italian Constitution. And in the Italian Constitution, it identifies the name, the nationality, the national name, the name of the state of the people of Italy. The people of Italy. Let me explain. The word people used, I'm going to explain both. The word people used in a political sense, the word people used in a general sense. So I'll give you the general sense first. The people in the park playing volleyball. That is the word people used in a general sense. But when the word people used in a constitution as the people of Italy, what does that mean, Abdullah? Good question. The word people and the people of Italy in the Italian Constitution means the repository, write this down, the people of Italy in the Italian Constitution. The word people means the repository of the collective sovereignty of the people vested in a constitution. Write this down.
That's what it means. That's what it means.
All right, once again, the word people used in a political sense, as in the people of Italy in the Italian Constitution, the repository of the collective sovereignty of the people vested in a constitution. Let me continue. Give me just 3 more minutes. That Italian Constitution protects all Italians worldwide. All Italians worldwide. Italy has treaties with various nation states. Italy has set up embassies and consulates. And Italy has her foreign representatives, ambassadors, consul generals, vice consuls, vice consuls, charge d'affaires. Italy also has a minister of foreign affairs, a minister of foreign affairs. All right, so you have the ambassador, consul generals, vice consuls, all under the minister or Ministry of Foreign Affairs of Italy. So we have to restore that principle.
The repository of what?
Of the collective sovereignty of the people vested in a constitution. This principle is very, very important, my brothers and sisters. This has not been taught really clarify conscious Moors have been doing individual upon individual upon individual upon individual upon individual. We must restore the national, I'm talking national principle. Means that applies to all Italians worldwide. We have to recover our lost Moorish sovereignty. We're on the road to recover our lost Moorish sovereignty. In 1968, the representative of Ceylon was in front of the United Nations Rights and Duties of State, United Nations Rights and Duties of State. United Nations had classified Ceylon as a new state. The representative in 1968 challenged the United Nations false claim. The representative showed that Ceylon had showed going back to the 19th century, which is 1800s, proving that Ceylon had relations, treaty relations, correspondence with other nations, that Ceylon was not a new state, but an old and original state, and should re-enter the founding nations under the reversion to sovereignty as an old and original state. This principle had not been taught until Shin Malachi Bey. This individual, we the people of the United States, that's the Moors, 35 Moors, was at the Constitutional Convention. I taught that to thousands of people for 25 years. That is a misconcept. So I know where it's coming from. I know where this individual upon individual upon individual, no concept of national principles. I know where it's coming from. I taught it. I apologize. I have to make an atonement for it. This is part of my making atonement. I'm part of effing your head up. I'm part of that. I'm part of the reason. I'm making atonement. Forgive me. I'm just atoning.
I just want to show y'all this.
You are forgiven, brother.
I want to show everybody this book. It's called The Creation of a State in International Law. Right. I just want to show y'all this book. I love that brother Abdullah. I talk to him every day. I talk to Abdullah every day. Every day. I got this book because of Abdullah. It's international understanding and framework. I got it from Abdullah. I was already understanding how the structure and stuff go through my litigation prowess. But I need you to understand. I got this book. I talk to Abdullah every day. We ain't playing no games, family. We teaching you, we killing these misconceptions. I'm trying to tell you. Hey, Mike, I want you to interject for 1 second, Mike. Just 1 second.
Yeah, go ahead, Mike.
Go ahead. No,
I want you to interject and just tell them, when we put that down, was it when you put the stuff into the record and they were trying to usurp your rights, but came back to acknowledge those rights? This tell them how much we put this together and how it panned out.
Yeah, it was meticulous. I mean, from A to Z. It on the record. I guess what I could say is every motion that was filed, they had to come back and acknowledge it, but they never. The record was skewed because they didn't want to make a record of the motions. They couldn't talk about them. So when I talked about them, they didn't talk about them. But the prosecution was stayed. The prosecution didn't say anything the whole time, which, when you really think about it, I guess, and maybe it's for the whole class, the prosecution never said a word. Abdullah said I didn't say a word, which was kind of true, but I did say something to the prosecution, but they didn't say one word. The prosecutor didn't say one word. So the whole time, they were stayed, and so the judge was actually acting as the prosecutor, which is how we got the record that we got, you know, for violating all of my rights. But they immediately acted right. Matter of fact, they're corresponding with me right now. I got a hearing on the 23rd. The judge set a special hearing for me on the 23rd to give me my car back. Yeah.
I want y'all to understand, man, I've been doing this too long. I'm not going to run you into a burning house. Abdullah is not going to run you into a burning house. We're trying to kill these misconceptions because a lot of people are proclaiming that, man, I did this, I filed this, and I know it's bull crap. I know it is.
Hey, can you see my screen if I show you something?
I don't know. I don't think so, Mike.
I can allow you to share it if you give me a second.
Okay. King, this is I guess maybe it'll be for the class, but this is the rental car bill from June, from when they took the car to the 23rd, King, for $49,000. You see that?
Yeah.
So this is from Sosa Exotic Cars in Miami, where I got the car rental from. And what do you want me to do with this now that I got this document?
We're gonna talk in private, Mike. I can't talk.
Okay. Yeah.
We'll discuss that in private.
Discuss that in private, Mike. Yes. All right.
So what I'm trying to, family, I've been doing this too long. This Mike case wasn't no accident. It wasn't no hack. It was based on understanding. Mike understands some things. I want y'all to understand that. So when Mike did his thing, it was based on understanding, knowledge. It was based on knowing legal principles. This one based off of some stuff that everything that I was saying was very sound, that the prosecutor people understood. You know, stuff that Mike was saying to the court was very sound. It wasn't by happenstance, accident. The stuff that was said in his motions was very sound. They knew based on what was presented, they had a hurdle to overcome. That's why they refused to answer or even entertaining them. They didn't want to entertain the emotions because it would have dug a deeper hole.
Can I interject?
Go ahead, my brother.
Peace to the brother Michael.
Peace.
Did you feel as though that the parties in the courtroom were almost trying to force you to waive your constitutional rights?
They were trying to force me.
And are you aware at the time that was a part of the prosecutorial misconduct?
Yeah, absolutely. So it wasn't, to be honest with you, it wasn't really the prosecutor misconduct. It was the judge. The prosecution was stayed. It was like the prosecution never wanted to bring the claim. This is how I felt. Now that hindsight's 20/20, but looking back, it's as if the state remained silent so the judge could hang herself. Because the judge completely brought the claim. The prosecutor never brought a claim. The prosecutor never brought a claim. They were stayed the entire time. So the first transcript, I don't know if they went over that in the beginning of class or not, but the first transcript from July 25th, the prosecution was stayed from that day. So the prosecutor never made a claim. He never stated a claim for relief to be granted from the very beginning. That's why when the judge asked me, she said, do you understand? And I said, well, I don't know the nature of the charge. And she said, well, I'm going to enter a plea in for you. I said, you can't, I need to know that willingly. I have to enter a plea willingly, knowingly, and intentionally. There's got to be 3 elements to enter into a plea. You have to understand it, and you got to do it knowingly, willingly, and intentionally. Otherwise, it's by threat, duress, and coercion. So the whole thing that the whole time she was doing was gaslighting, because the prosecutor never brought the claim. So the whole time she was trying to get me to waive my constitutional rights. Because if I would have waived any right, she would have then had jurisdiction. Because I did I didn't do a lot of the Moorish stuff, but I did file my affidavit. I did do that. And I did tell her I was not Michael James Longs. I told her I was Michael James Longs Bay for status, for whatever. And she did, she did skip over that. She didn't acknowledge that per se. But she didn't acknowledge anything. But her whole goal was to adjudicate no matter what happened. And if you just by looking at the transcripts, you can see the prosecutor never said a word. Her whole intention was to adjudicate, but that's because here in Florida and everywhere else, they got the court registry investment system. That's the CRIS. It's called the CRIS. Everybody can look that up. It's called CRIS, Court Registry Investment System. And that system is what they're using to funnel in all the funds. So every judge, every lawyer, every prosecutor is a part of that. So when they take an oath to uphold the Constitution, but they're misappropriating the funds, from your bail, so they're investing all those funds. That's an automatic conflict of interest. She's got a conflict of interest immediately because she's getting proceeds off they got stock. We're literally livestock.
But Michael, King, what? All right, we still missing the point though. I hear you, Michael.
Tie me back in, Abdullah. Tie me back in. Yeah.
All right. We're missing the point here. We want to make sure the point, because the point is getting lost.
Yes, sir.
Once again, King, I need you to explain to us what Michael should have said. What Michael should have, because they still didn't prevent you, Michael, from talking. We read the transcripts, Michael, not the one on the 20th of July. You still were going back and forth with the judge.
Right.
He still didn't prevent you from speaking to the prosecutor. Nothing prevented you. You're
right.
From speak. That's what I wanted to be clear. Let's be clear. I heard you say, but I'm a good listener.
No, you're right.
Everybody read. Everybody saw the part. Nothing prevented you. Nothing prevented you. All they're part of financial and they together and but the judge. Nothing. None of that prevented you at that moment to speak to the prosecutor. Nothing. King, you have the floor. Tell us what Michael should have said.
Mike should have addressed the prosecutor, and he should have asked the prosecutor what is the jurisdiction that he's trying to invoke. It got to be identified. And what is his claim? Did he perfect his claim? He should have been asking him questions according to the constitutionality as it relates to due process, as it relates to this case, the substantive language. Did he get his motions? Did he understand his motions? And why didn't he respond in a timely fashion? Because each motion that you file and his response have what they call a time computation. And why he didn't respond? It's not for the judge to make a decision or to argue. And if the judge wants to interject, you have to strike and ask the object to the honorable judge answering for the prosecutor. This is a question solely for the prosecution, and allow the prosecution to identify what he was trying to do. What had happened was Mike allowed the prosecutor to remain silent and allow the judge to move the court according to how she was seeing things, instead of allowing Mike not to engage into the judge and see if the judge agreed with see if the prosecutor is in agreement with the judge. For example, when the judge said, well, I didn't get served, you should have said, Your Honor, prosecutor, do you agree with the judge that for her to deny the hearing of these motions, that she has to be personally served? I'm asking you. As a prosecutor, you are a officer of the court. this up. You should have been throwing everything back to the prosecutor. The judge is making statements, okay? And if the judge is going to make them statements, have the judge identify the source of law. What source of law is that you're applying? Under what application? Under what principle it is that you're using, Your Honor? Could the court answer those questions? Because the court seemed to be very talkative. And it seemed that the court is trying to speak on the behalf of the prosecutor. So if the court is going to do that, let's go ahead and let's get down to some business. Tell me the source of law so I can fact check everything, so that I can dispute, to create a record for an appeal to see if this is plain error or either abuse of discretion. But then I would have got back onto the prosecutor.
Yeah, I'm overstanding now and catching your drift, because like I'm in the Pennsylvania territory as we speak, and most of that stuff, most of everything is written out plainly in the rules of civil procedure here, or in the in our local rules. But it's not in plain English as far as like how you breaking it down. It's just that going through each I guess they're like a canon, like referring to a canon. If it's biblical in nature, it makes sense. But if it's like written out in legalese, you won't catch the drift of
it. Is everybody clear on this? This is major point here, and I know that we've been conditioned. I know to go back and forth with the judge. I know that, and I appreciate King. We spent it, quite a bit of time on this, but we have to. We have to, because we got to make sure that these fundamental concepts are solid. We can't rush past them. We can't rush past this because the misconceptions been there. You've been listening to X persons for 10 years or 5 years or 3 years, and you listen to that X natural person, conscious more for every day, about every day, and it's both. So, I understand. I was there. I got you. I get it. It's understanding the roles of the prosecutor, the judge, and the defendant. The judge and or magistrate is an umpire or a referee. What is a role of a basketball referee? What is a role of a baseball umpire? Let's do that. What is the role of baseball? Let's go there. Umpire, referee. I mean, the principle ain't different. How's it different? Talking about just a sound principle as far as the role of a baseball umpire and a basketball referee. They're neutral parties. All right, so King, are we ready? We're gonna Amanda, we're gonna go to the motions. We're gonna go to the motions.
I was wondering if I could read something for the panel before y'all started.
What is it, brother? Before I agree, what is it?
Islam. Is there recording on this?
Absolutely. All five. I got a feedback. I'm getting a feedback. I'm gonna have to cut all 5 of the previous educational sessions are on the Moroccan Post Media YouTube page. This will be available between this evening or tomorrow. Upload on the Moroccan Post Media YouTube page. All 5 sessions are available on Moroccan Post Media YouTube page. Yes, so it'll be available either this evening or tomorrow. Yes, you can share it. All right, you can share it. You can post it on your Facebook page and other social media platforms. Yes, you can text it to other people, email it, however you want to do it. Yes. All right, what do you want to read, brother?
Is it me?
Am I still muted? Can you hear me?
No, somebody said they want to read something. I want to know what it is before I can't say yes or no to something that I don't know.
Yeah. Oh, This is Brother Rashid. I wanted to read an excerpt from the misconduct and plea bargain process within the legal scope of the conversation.
Is it long?
No, it's just the excerpts from it. It's
I mean, I don't know. I mean, I'm just, you know, you know.
It's not
Well, you need.
it's not a paragraph or nothing. It's just
All right, go ahead, brother. Yes, yes.
Yeah, just to put the people on game. Here in this Pennsylvania territory, they do have what is called inducements to plead guilty, and that is, it just states there are a number of ways a prosecutor may induce a guilty plea. And the other part is just inducements to plead guilty under false promises, fraud, or misapprehension of conditions. That was all.
King, based on the legal principles. All right, so we're looking at the rule of law. Rule of law is a primary legal principle. Rule of law is a primary legal principle based on the rule of law of fairness, equality, accountability, accessibility, and no arbitrariness. That's fairness, equality, accessibility, accountability, and no arbitrariness. Based on the rule of law, those are major elements of the primary legal principle. Rule of law is a primary legal principle, and those I mentioned 5 elements of the rule of law. So I want the brother to reread that and keep the rule of law: equality, fairness, accessibility, no arbitrariness, and accessibility, equality, accountability, fairness, and no arbitrariness. So I want y'all to read. I want him to reread that, and I want you to use the rule of law as your measurement guide. Go ahead again. Read it again, Bo.
Okay, I was on mute for a second. And
reread it, brother.
And I just lost it. Hold on one moment. All right, I'm back.
All right. All right.
Inducements to plead guilty. There are a number of ways a prosecutor may induce a guilty plea. Inducements fall under false promises, fraud, or misapprehension of conditions.
All right, so based on the rule of law, fairness, elements, based on the elements of the rule of law, the legal principle, the primary legal principle of the rule of law: equality, accessibility, fairness, no arbitrary decision, and accountability. You want to measure it by that, not that he's reading it and it is because he's reading it. It is because it's in the book. No. Use the legal.
I just want to add real quick. Furthering that, they have what they call professional rules of conduct. That is also the birth of the rules of law. You understand what I'm saying? Equity, we got to understand, help created these rules, understanding the rule of law, which also spill over to the rules of professional conduct and judicial conduct. Based on these rules, the rule of law, they gave birth to these other rules. All these other rules, civil rules, all of these different things came from the rule of law principle. It gave birth. It's the mother. It gave life to these other rules. When you understand these rules, it makes your life real simple. But you have to use due diligence to understand this. I just wanted to emphasize that to help break down this, right? So when we looking at that rule of law, you can correspond with that also, further evidencing, right, his action based on a professional rules of conduct. They correlate. They correlate. I've been doing this for a long time, family. I'm not going to run you into a burning building. We're killing
Appreciate that, brother. Yeah, absolutely. Thank you. Thank you for that, brother. How you pronounce Rashid? How you pronounce your name, brother? Rashid? Rashid.
Yes, that's
Thank you.
absolutely correct. Yes.
Rashid. All right. So Rashid, you want to read? You want to read,
Greetings,
Rashid?
Mr. Sheik.
Read the screen. The screen.
Yes, yes.
In the court of the 10th Judicial Circuit and for Polk County, Florida, State of Florida, plaintiff versus Judge Hope M. Patty, Michael James Long Bay, defendant. Motion to be heard. Comes now Michael James Long Bay, the defendant in error, and respectfully moves this court to reconsider the magistrate's decision from the hearing held on August 20th, 2024, during which the defendant's motion was not heard due to an alleged failure of proper service to the magistrate. The defendant asserts that he properly served the prosecutor in a timely manner in this instant case, and the prosecutor did not object at the hearing. See affidavit in support by Michael Long Bay and Exhibit HH, transcript page 2. Grounds for the motion.
No, you got to finish reading it, brother. Hold on, finish reading it. Read what's there.
Okay,
Transcript page 2, line, go ahead, line.
Line 1-25, page 3, line 1-25, page 4, line 1-25, period. Grounds for the motion. 1, timely filing and service compliance. The defendant timely filed the relevant motions with the clerk of the court of the 10th Judicial Circuit and for Polk County, Florida, and received timestamped copies confirming the filings. The defendant received applicable procedural rules, including the Florida Rules of Civil Procedure, Florida Rules of Criminal Procedure, Florida Traffic Court Rules of Procedure, Florida Rules of General Practice and Judicial Administration, and the local rules of the 10th Judicial Circuit, and found no specific requirement mandating personal service of motions upon the magistrate. This constitutes a plain error and an abuse of discretion by the magistrate, resulting in the defendant being denied his right to be heard. Keep reading. Number 2.
Yes, please.
Violations of constitutional rights. Denial of the defendant's right to be heard violates the 5th and 14th Amendment to the United States Constitution. But I gotta zoom out.
All right, brother, you can you see it?
Yeah, I can see it good. So which guarantees the right?
Continue.
Okay. Which guarantees the right to due process in a fair trial or fair hearing. The denial of a hearing on the defendant's motions without just cause undermines these fundamental principles or protections by preventing the defendant from creating a record for appeal, thus denying the right to an effective defense and access to appellant review. Footnote 1, see Matthews versus Eldridge. That's 442 U.S. 319 333 1976, where the U.S. Supreme Court emphasized that due process fundamentally requires the opportunity to be heard. Oh, let me read that again. The United States Supreme Court emphasize that due process fundamentally requires the opportunity to be heard at a meaningful time and in a meaningful manner. Footnote 2, Article 1, Section 9 of the Florida Constitution similarly guarantees that no person shall be deprived of life, liberty, property without due process of law. Number 3, failure of the magistrate to acknowledge proper service. The oversight regarding the alleged need for personal service upon the magistrate is unsupported by Florida procedural rules. The defendant's motion or defendant's actions were in accordance with the Florida law, which does not explicitly require personal service on a magistrate, but rather mandates proper notice and service upon parties involved, specifically the opposing counsel or prosecution. Footnote 3, see Florida Rules of Judicial Administration 2.516, which details the service of pleadings and papers, emphasizing service upon parties rather than judicial officers. Number 4, irreparable harm from denial of motion hearing. The denial of the defendant's motion to be heard causes irreparable harm by preventing the defendant from establishing a record of appellate review, thereby infringing upon his right to appeal. 2, obstructing the defendant's ability to mount a defense, as denial of the motion hearing effectively silences the defendant's right to present arguments in his defense, a fundamental due process violation that could result in unjust penalties, including incarceration. Footnote 4, refer to Powell versus Alabama, 287 U.S. 4568-69, 1932, which underscores the critical nature of a defendant's right to be heard in their own defense as a fundamental component of due process. Number 5, prosecution's non-opposition. It is of note that the prosecution neither objected to nor responded to any of the defendant's motions. This lack of opposition underscores the procedural rather than substantive nature of the oversight and further supports the necessity for the court to grant the defendant's motion to be heard. It says, wherefore Michael James Long Bay, the defendant in error, respectfully requests that this court, 1, grant this motion to be heard, correcting the procedural oversight regarding the non-service of the magistrate, ensure the defendant's constitutional rights are upheld by allowing a hearing on the previously filed motions, and number 3, provide any other relief demanded, just and proper. Respectfully submitted.
Go down to the service, go down certificate of service. Go back, yeah, certificate of service, read that.
Certificate of service, okay. I hereby certify that a true and correct copy of the foregoing motion to be heard has been finished by hand delivery to the prosecutor's office on August 30th, 2024.
Brother King?
It's furnished by hand. It's furnished by hand.
Furnished.
Yeah.
You want to, before we go on, King, you want to make a comment?
So I was breaking down to make sure that the judge understood that we understand the law and that we were procedurally sound in perfecting our rights, and the preservation of Mike preserving his rights, that he understood what he needed to be doing, right? So Mike, understanding what he needed to do, he presented this argument, right, to the court. So upon presenting this information to the court, they knew that he was procedurally sound. And I don't think the court wanted to, or the prosecution wanted to challenge these motions, challenge this particular motion.
All right, so can we, Brother Vicarious?
Yes, sir.
You want to take over?
Okay, affidavit in support of motion to be heard. State of Florida, County of Polk. Michael James Long Bay, being duly sworn, do hereby depose and state as follows. 1, I am over the age of 18 years and of sound mind. 2, I have firsthand knowledge to make this affidavit regarding the circumstances surrounding the hearing held on August 20th, 2024.
So
3,
slow it down. Slow it down, my serious.
Got you. 3, I am the defendant in the above captioned case. City of Florida versus Michael James Long Bay. Case number 53-2024-MM-005136-A000-BA. On August 20th, 2024, my motions were scheduled to be heard. However, they were not addressed due to an alleged failure to serve the magistrate. 5, I properly served all motions on the prosecution, filed them with the clerk of the court, and received time-stamped copies. 6, upon reviewing relevant Florida procedural rules, I found no requirement for personal service of motion on the magistrate. 7, I believe my right to be heard as protected under the 5th and 14th Amendments was violated due to this procedural error. 8, the prosecution did not object to or respond to my motions, indicating no opposition to the content of the motions themselves. 9, I respectfully request the court grant my motion to be heard to correct this oversight. I declare under penalty of perjury that the foregoing is true and correct to the best of my knowledge, information, and belief. Florida Notarial Certificate, Jurat, State of Florida, County of Hillsborough, sworn to be or affirmed and subscribed before me this 30th day of August 2024 by Michael James Long Bay. Signature of notary.
All right, so we go to the next one, Amanda.
Do you want me to speak on that?
Yeah, please do. I apologize. Yes.
Okay, so the thing I want y'all to know, when you file motions, right, they have to be supported by affidavits and other exhibits. Don't just put in a motion. Have the supporting elements. It's a fact-finding tool. Understand what you need to do to present your case to perfect your claim. When you understand how to do this, that's why the judge, they ain't want to touch it. They ain't want to touch this. Now somebody got to answer these questions. I just wanted to say that. We can move on, Amanda.
You are unmuted. Greetings. Once again, this is Missionary Sheep Red Cloud. I'm in the middle of traveling New Jersey Republic. Can I get that recording recite again so I can write it down, please?
Get what? What?
The recording of this.
It'll be on the Moroccan Post Media YouTube page.
Okay, Moroccan Post
Media.
Okay. Moroccan Post Media. Okay. Thank you.
You're welcome.
Anybody want to read this? Anybody want to read this?
I got it, King. All right, in the county court of the 10th Judicial Circuit. In the county court of the 10th Judicial Circuit in and for Polk County, Florida. State of Florida versus plaintiff Michael James Long Bay, or defendant. Notice of motion for injunction relief. To the clerk of the court, Judge Hope Patty, and all interested parties. Please take notice that Michael James Long Bay, defendant in the above captioned matter, hereby gives notice of his intent to file a motion for injunction relief pursuant to Florida Appellate Rule number 8, seeking to address ongoing violations of due process rights by this court. The defendant contends that the actions of this court under the supervision of Judge Hope Patty have violated fundamental principles of due process. Should these actions continue, the defendant will seek a preliminary injunction to prevent further infringement of his constitutional rights and to ensure the fair administration of justice. In accordance with Florida Appellate Rule 8, the defendant respectfully requests that this court immediately review its procedures to rectify any and all due process violations. If corrective action is not taken, the defendant will have no choice but to pursue further injunctive relief to protect his rights. Respectfully submitted, Michael James Bay. Certificate of service, I hereby certify that a true and correct copy of the foregoing notice of motion for injunction relief has been furnished to the Office of the State Attorney, Polk County, Florida, via method of service, example US, or e.g. example US mail electronic service on this date. Oath of loyalty for judges. Let me get this right. I believe it's section 876.05, Florida statute, state of Florida, county of Polk. Hope Patay, a citizen, resident of the state of Florida and of the United States of America, and being an officer of the Florida state court system and a recipient of public funds as such, officer do hereby solemnly swear or affirm that I will support the Constitution of the United States and of the state of Florida. Notary sign, notary stamp. Continue. The County Court of the 13th Judicial Circuit in and for Hillsborough County, Florida, City of Florida plaintiff versus Michael James Long, defendant, in error. Motion to withdraw plea of not guilty and to not enter plea. Comes now Michael James Long Bay, the defendant, appearing sui juris pursuant to Rule 3.170F of the Florida Rules of Criminal Procedure, and respectfully moves this honorable court to permit the withdrawal of the previously entered plea of not guilty and to abstain from entering any plea at this time. The defendant states the following as grounds for this motion. 1. Introduction. On July 25th, 2024, I, the undersigned defendant, did not enter plea of not guilty to the charges as set forth in the information. I am now seeking to withdraw this plea and refrain from entering a new plea pending proper clarification of the charges against me. 2. Failure to identify nature and cause of the accusation. The prosecution has failed to sufficiently identify the nature as a constitutional element of the Sixth Amendment to invoke proper standing in this matter. This failure deprives me of my fundamental right to be informed of the nature and cause of the accusation as guaranteed by the Sixth Amendment of the United States Constitution. The distinction between the nature and cause of the action as clarified in the United States versus Cruikshank 92 U.S. 542, 1875 mandates that these elements be separately defined to afford an accused be separately defined to afford an accused adequate information to prepare a defense and to plead double jeopardy where applicable. Number 3, request for clarification. Before any plea can be considered or entered, it is essential that the prosecution clearly define the nature of this instant case as a constitutional requisite.
Stop there. Stop there. Hold on. About serious. I want you. There we go. This is very important. It doesn't say read. It doesn't say judge. It doesn't say judge. It doesn't read judge, right? Read it again, Pastor. I might have overheard, so I thought I heard. I didn't hear judge, did I? I heard what? I heard, read it again. I didn't hear
Number
judge,
3,
right?
Number
Yes.
3.
Yes.
Request for clarification. Before any plea can be considered or entered, it is essential that the prosecution clearly define the nature of this instant case as a constitutional requisite. The prosecution clearly defines the nature of this instant case as a constitutional requisite.
Oh, I'm telling you, these motions is something serious. They something serious. Oh, these motions is something serious.
All right, continue, Serious.
Number 4, legal and judicial economy. Addressing these concerns at this stage will promote judicial economy by potentially avoiding unnecessary proceedings. It will ensure that the proceedings, if any are to proceed, are conducted under clear, lawful,
all right,
and
Serious?
just terms. You hear me? Hello?
Yeah, we hear you, brother.
Okay.
Serious.
Yes, sir.
You stopped.
He stopped at the end of the sentence.
All right. Wow.
So that was number 4.
That was number 4.
I'll read it again.
Read it again. Please read it again. I apologize.
All right. Legal and judicial economy. Addressing these concerns at this stage will promote judicial economy by potentially avoiding unnecessary proceedings. It will ensure that the proceedings, if any are to proceed, are conducted under clear, lawful, and just terms. Right. Wherefore,
go ahead.
Wherefore I, Michael James Long Bay, respectfully request that this court grant this motion to withdraw the plea of not guilty, order the prosecution to clarify the nature and cause of the accusation, and allow me to abstain from entering any plea until such clarification is provided. Furthermore, I request the court to dismiss the case should the prosecution fail to establish clear grounds and lawful authority. Certificate of service. I hereby certify that a true and correct copy of the foregoing motion was furnished by electronic delivery on this August 9th, 2024 to the prosecutor. Respectfully submitted, Michael James Long Bay, defendants and jurors.
All right.
I want y'all to see the technique, the legal, the language in the motions, man. Look at what's going on.
All right, so can we have another reader?
I'll take over.
All right.
in the County Court of the 10th Judicial Circuit and in 4 Polk County, Florida. Michael Longs Bay, petitioner versus State of Florida, and Hope M. Patty, respondent. Defendant in error's motion to require the filing of the judge's oath of office into the case file. Comes now the defendant in error, Michael Longs Bay, appearing sui juris and under special appearance by way of threat, duress, and coercion in case number 2024 MM-005136-A000-BA, and hereby moves this honorable court to order the filing of the presiding judge's oath of office into the case file. In support of this motion, the defendant in error states as follows. 1, legal basis for the motion. 1, constitutional requirement. Under both the United States Constitution and the Florida Constitution, a judge must take and file an oath of office prior to exercising judicial authority. This requirement ensures that the judge acts within the bounds of their constitutional duties and adheres to the principles of impartiality, fairness, and justice. 2, Florida statutory requirements. Florida statutes section 876.05 mandates that all state officers, including judges, must swear an oath of allegiance to the United States and the state of Florida before entering office. This oath is a precondition to the lawful exercise of judicial powers. 3, due process considerations. The defendant in error has a fundamental right to due process, which includes the right to be judged by a legally qualified and duly sworn judge. The absence of a valid and properly filed oath of office calls into question the jurisdiction and authority of the court to preside over this matter. 2, request for production and filing of the oath of office. 1, the defendant in error respectfully requests that this honorable court order the production and filing of the presiding judge's valid oath of office into the official case file. 2, the defendant in error further requests that the court proceedings be suspended until such time as the oath of office is properly filed, as the legitimacy of the court's jurisdiction is contingent upon the judge's lawful authority. 3, legal support and case law. 1, Marbury v. Madison, 5 U.S. 1 Cranch 137, 176 in 1803, establishes a principle that acts by a government official that are not supported by the Constitution are void. A judge acting without having taken and filed the required oath lacks the lawful authority to preside over any proceedings. 2, Henry Duncan, 139 U.S. 449, 1891. The United States Supreme Court held that the legitimacy of a court's actions depends on the proper appointment and qualification of its officers, including the taking and filing of an oath of office. 3, Florida statutes section 876.05 requires that an oath be taken and filed by all officers of the state, including judges. The absence of a valid oath can invalidate actions taken by the court. 4, conclusion. Wherefore, the defendant in error, Michael Longs Bay, respectfully moves this honorable court to A, order the production and filing of the presiding judge's valid and current oath of office into the case file as a precondition to continuing these proceedings. B, suspend all proceedings in this matter until the above request is fulfilled. C, grant any further relief this court deems just and proper. D, the immediate return of the 2017 Dodge Charger to the registered agent of Solid Solution LLC. August 23rd, 2024, respectfully submitted, Michael Longs Bay, Certificate of Service. I hereby certify that a true and correct copy of the foregoing motion to require filing of the judge's oath of office into the case file has been furnished by electronic service on August 23rd, 2024.
Brother King.
This was more of Mike's technician. This is a solid motion based on that the judges or officials or any type of officer of a court have to have this on record to submit evidencing that they can make a decision. you can do this motion. This is a motions that you can do because you're making sure that the requisite that they have took an oath to ensure the integrity of the process. You have a right to do that. So when looking at these motions, that's a very good motion to put in.
All right, so this is a motion to dismiss. Has this been read already, Amanda?
I don't believe so.
All right, we have another reader. Step right on up. You are the next contestant on The Price is Right.
Hey, if don't nobody want to read, want me to continue?
Go ahead, everybody serious. Go ahead, you got it.
All right, the County Court of the 13th Judicial Circuit in and for Hillsborough County, Florida. State of Florida plaintiff versus Michael James Long Bay, defendant in error. Comes now the defendant in error, Michael James Long Bay, who is sui juris and respectfully requests that this honorable court dismiss the charges brought under 322.035, 322.035-606, EXPDL more than 6 months for failure to state a claim for which relief can be granted as follows. The defendant is charged with violating Florida Statute 322.035, 322.035-606, EXPDL more than 6 months. What is it? Expired driver's license more than 6 months, if I'm correct on that. 1, introduction. This memorandum addresses the jurisdictional principles related to non-U.S. citizens under the Treaty of Peace and Friendship between the United States and various foreign powers, specifically focusing on the historical Treaty of Peace and Friendship with Morocco. This analysis outlines how such treaties influence jurisdictional matters involving non-U.S. citizens in the United States. 2, Treaty of Peace and Friendship. A historical context. The Treaty of Peace and Friendship with Morocco, signed on June 28, 1786, represents one of the earliest formal agreements between the United States and a foreign power. This treaty established diplomatic relations and outlined various mutual protections and rights for citizens of both nations. B, key provisions. 1, Article 23. This provision guarantees that the subjects of the United States of America shall have free and unrestricted access to all ports of the Moroccan Empire. And conversely, Moroccan subjects shall have similar access to U.S. ports. It aims to facilitate mutual trade and protection. Number 2, Article 24. This article stipulates that if a U.S. citizen commits a crime in Morocco, they are subject to Moroccan laws, whereas Moroccan subjects in the U.S. are subject to U.S. laws. This provision underscores the principle of reciprocal legal treatment. 3, jurisdiction over non-U.S. citizens. A, principles established by treaties. 1, equal treatment. Treaties such as Treaty of Peace and Friendship typically establish the principle of equal treatment. Non-U.S. citizens are generally entitled to similar legal treatment as U.S. citizens under analogous circumstances within U.S. jurisdiction. 2, consular protection. Non-U.S. citizens may be entitled to consular assistance from their home country under such treaties, which can influence jurisdictional proceedings. For instance, if a non-U.S. citizen is arrested in the U.S., their consulate may intervene to ensure compliance with international agreements. B, jurisdictional limits. 1, criminal jurisdiction. The U.S. maintains jurisdiction over non-U.S. citizens for criminal activities conducted within its borders. Treaties do not usually provide immunity from U.S. jurisdiction, but may specify procedural rights and protections. 2, civil jurisdiction. Treaties may impact civil jurisdiction by providing certain protections or limitations in the treatment of non-U.S. citizens. These provisions are designed to ensure fair legal processes and respect for treaty obligations. C, extradition and legal cooperation. Treaties often include provisions concerning extradition and legal cooperation, which affect jurisdictional matters involving non-U.S. citizens. These provisions generally require that individuals be tried according to the laws of the country where the alleged offense occurred, ensuring adherence to international legal standards. 4, conclusion. The Treaty of Peace and Friendship and similar agreements establish mutual rights and protections for citizens of the signatory countries while setting forth principles for jurisdictional issues. Non-U.S. citizens are not exempt from U.S. jurisdiction, but are afforded certain procedural rights and protections under these treaties. The application of such treaties influences how jurisdictional matters are managed, particularly in criminal and civil contexts. Failure to state a claim, given the defendant's lack of action in not obtaining a license under Florida Statute 322.035, 322.035-06, expiration of driver's license more than 6 months, failed to meet requisites of the offense. 1, introduction. Prayer for relief. Wherefore the defendant requests that this honorable court dismiss the charges with prejudice for lack of standing and failure to state a claim upon which relief can be granted. Conclusion. Based on the factual background and legal arguments presented, it is respectfully submitted that this motion to dismiss be granted. Constitutional foundation. The representatives of the people in the Republican form of government, by signing the Constitution, entered into an ironclad contract enforceable in a court of law pursuant to the statute of frauds. This contract should be honored and enforced by the court in favor of the clearly intended and expressly designated beneficiary, namely the citizens. Supremacy Clause. Article 6, Paragraph 2 of the United States Constitution, known as the Supremacy Clause, asserts that the Constitution, along with the laws of the United States made in pursuance thereof, and the treaties made under the authority of the United States, shall be the supreme law of the land. Judges in every state are bound by it, and any state law or constitution that conflicts with it is null and void. Legal precedent. In the landmark case of Marbury versus Madison, 5 U.S. 137, 1803, the opinion of the court established that any law conflicting with the Constitution is null and void. The supremacy of the Constitution takes precedence over any other law, ensuring that secondary laws do not conflict with the supreme law of the land. Judicial duty. It is the duty of the courts to enforce the contract embodied in the Constitution and to honor the provisions therein, especially when a claim or defense is based on constitutional grounds. The court should apply these principles in favor of the defendant. 5 constitutional interpretations. Upon investigation, it is evident that the Constitution should be enforced as outlined in American Jurisprudence, Volume 16, Constitutional Law, Section 97. It states that a constitution should receive a liberal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to both person and property. See note 31, Breyer versus United States, 273 U.S. 28. Right to travel. The defendant asserts his right to travel as established in Shapiro versus Thompson, 394 U.S. 618, Murdoch versus Pennsylvania, 319 U.S. 105, 1943, and Shuttlesworth versus City of Birmingham, 373 U.S. 262, 1963. Now, Shuttlesworth holds that if a state converts a right into a privilege and charges a license and fee, the individual may ignore the license and fee and engage in the right with impunity, as the state cannot punish the individual for exercising this right. Willful intent. According to U.S. versus Bishop 412, U.S. 346, 1973, willfulness is defined as an evil motive or intent to avoid a known duty or task under the law with immoral certainty. This case sets a standard for proving criminal violations in terms of willful intent. The burden is on the prosecution to prove that the defendant willfully and knowingly avoided a known duty or task with immoral certainty. Given the constitutional immunity and the principles established in the aforementioned cases, the prosecution cannot fulfill this burden. Request for relief. Since the prosecution cannot establish a cause of action for which relief may be granted, and considering the constitutional principles that preclude the charges, the defendant respectfully requests that this honorable court dismiss the charges with prejudice. Additionally, the defendant requests the court to award costs and fees incurred in defending against this patently frivolous and spurious complaint. Florida Constitution, Article 1, Section 2. This section provides that all natural persons, female and male alike, are equal before the law and have inalienable rights to travel. 10. State versus Williams, 229. SO 2D 240. I guess Florida, 1969. This case affirmed that travel is a fundamental right protected by the Constitution. It underscored that any state law restricting travel must be narrowly tailored to serve a compelling state interest. Parsley A. State 453, SO 2D 179, Florida 2D DCA 1984. The court held that restrictions on an individual's right to travel must not be overly broad or infringe upon the person's constitutional rights more than necessary. 12, State versus Knight, 24, FLA, Weekly, D2112, FLA 4th DCA 1999. The court examined the constitutionality of statutes affecting an individual's ability to travel and concluded that such statutes must align with constitutional protections and not unduly restrict the right to travel. Respectfully submitted, date 8/9/2024, sui juris, Michael Long Bay. Certificate of service, I hereby certify that a true and correct copy of the foregoing motion to dismiss has been furnished by electronically delivery to the prosecutor located at 9th August 2024.
Okay, family. I'm gonna have to address that motion. That motion was kind of incorrect. This motion is incorrect. Let me tell you why. You don't mention treaty and then argue constitutional element. If you're going to argue treaty, and wouldn't be the venue, this is improper venue. The Treaty of Peace and Friendship would be the improper venue. So this is why I talk about when we do things and overstep certain things without having legal sound knowledge. He's arguing the Treaty of Peace and Friendship. It's not the proper venue to argue. Then arguing the Constitution in conjunction with arguing the treaty. They're two separate instruments. They're both living instruments. I want you to understand this. Why they're living instruments? They're dealing with living people, right? The treaty in particular deals with a particular group of people, and the Constitution deals with a particular group of people. They do have nothing in common. They're not of the same essence. As it denotes, the treaty denotes Moors, and the stuff that's argued in this denotes citizens of the United States. Two separate institutions. First of all, under international law, I don't have the right to interfere in other nations' territory. I don't have that right. I can't go into and start arguing something if I'm outside of their jurisdiction. No other country has the power to come in and start meddling in other countries' affairs. That's not how that works. Unless there's some outcry of what the people are being, denied rights, abuse, and all that stuff on the international, then there's international treaties that a lot of the countries sign. But this motion is kind of improper based on the two elements. You would never argue treaty and then turn around and argue the U.S. Constitution. Anything regarding any United States law.
King, let me give him some cases. I'm going to give him some cases to support. I'm going to support King finding of facts. So finding of facts. So let's deal with some finding of facts to support Brother King's claim. Brother King made a claim, and we're going to use finding of facts to support the claim. All right, here we go. Give me 1 minute here. Howenstein versus Lynham. Howenstein versus Lynham. I'm going to give you a series of cases, and I'm going to talk about each one. These are fact findings to support King's case. Supports King's claim. All right. Howenstein, H-A-U-E-N-S-T-E-I-N versus Lynham, L-Y-M-A-N, 1879. Howenstein versus Lynham. Ware versus Hilton, W-A-R-E versus Hilton, H-Y-L-T-O-N, 1796. Ware versus Hilton. Society versus New Haven, 1843. That's Society of the Society versus New Haven. The full title, Society of the Propagate, but Society versus New Haven, 1843. All right, so let's deal with the cases. I'm going to start with Howenstein versus Lynham. Howenstein versus Lynham, 1879. The United States, Howenstein versus Lynham, Solomon Howenstein purchased 3 properties in Virginia. When he transitioned, when he died, this might be too bright here, yes. When Howenstein died, his niece and nephew came from Switzerland and made a claim. Virginia state enacted a law that Virginia state could keep the proceeds from the sale of the property. Virginia state had sold Solomon Howenstein's property. Virginia had enacted a law that the state could keep the proceeds from the sale. Article 5 of the treaty, of the 1850 treaty, not the United States Constitution. Article 5, there wasn't, when they used the treaty of 1850 treaty between the Swiss Confederation and the United States, and they had the United States Constitution, and then back and forth. They didn't. That's why Keng say that's improper. So I'm showing you a case so you can read for yourself, not what Keng said, not what Abdullah say. Read it for yourself. You're not going to see that. Article 5 of the 1850 treaty between the Swiss Confederation and United States allows a United States citizen in Switzerland to receive the proceeds of sale of the property. Also allows that would be a United States national in Switzerland. Allows a Switzerland national in the United States to receive pro-sales from the sale of the property. It first had to be determined whether Howenstein had renounced his allegiance and citizenship to Switzerland. Once it had been determined that Solomon Howenstein never renounced his allegiance and Switzerland and allegiance and citizen to Switzerland, then the 1850 treaty between the Swiss Confederation and the United States kicked in. They didn't go, you're not going to see, only reference to the United States Constitution, the last 3 pages. The last 3 pages of this case, summary. The reference to the United States Constitution is the Supremacy Clause, where it makes it very clear that if a state, and I want y'all to read the last 3 pages, they go in. If the state can enact a law, then the state would have power, can enact the law that will overturn a United States Constitution. Because that's a Supremacy Clause. Where the treaty, meaning when it reads in Article 6 of the United States Constitution that treaties are the law of the land. Let me explain what that means so we get clarity. When it says treaties are the law of the land, that doesn't mean that the 1850 treaty between the Swiss Confederation and the United States applies to everybody. It doesn't mean that. So we got to get proper interpretation. It doesn't mean it applies to everybody on the land. What it means is binding on the state. That's what it means. Supreme law of the land means it, and that binding on the states. Let me give you the history. Michael knows this. Let me give you the history and jurisprudence of Article 6 of the United States Constitution. I got to do this. The history and jurisprudence of Article 6 of the United States Constitution. In 1780, this guy got to give you the history. In 1780, all of the 13 states had enacted a law, the Confiscation Act and the Trespassing Act, against the Tories. The Tories or Loyalists. Tories is a political party in Great Britain. the Tories and loyalists are synonymous. The loyalists is a political party, Tories in Great Britain. Loyalists is those who remain loyal. You got the patriots, and you got the loyalists. Patriots, United States. Loyalists, Great Britain. Great loyalists are those who remain loyal to Great Britain. They're called loyalists. So the 13 states enacted the Confiscation Act and Transpacted Act against the loyalists or Tories. These were wealthy Tories who had 2,000 acres and so forth. All right. So remember, you're still at war. Remember that you didn't have the treaty yet. The Revolutionary War didn't end yet. Alexander Hamilton represented Tories. He said, why would a patriot, Alexander Hamilton, represent Tories, loyalists to Great Britain in 60 cases? Because he's a lawyer and these are wealthy loyalists and Tories, and he wanted to get paid. So he represented 60 Tory cases. Now, after the treaty that ended the Revolutionary War between Great Britain and the United States, the 1783 Definitive Peace Treaty between Great Britain and the United States that ended the Revolutionary War, the states continue to act that they were doing, in 1780, 1779, 1780, 1781, 1782, 82, the states were still doing the acts of violating, now it's a treaty violation because now the treaty is enforced. It's now a treaty violation. The Great Britain refused to remove the troops. Great Britain refused to remove the troops until the states honored the treaty. Now you got a mess going on. All right, because now the states are violating. So now John Jay, so the article under the Articles of Confederation, this is all important, my brothers and sisters, please, this is very important. You need to understand the history and jurisprudence of Article 6 of the United States. I don't just read. So when I read it now, it has more meaning. So when you now read Article 6, it has more meaning to you. It didn't just come out of thin air. All constitutions don't have that. All constitutions don't have treaties or the supreme law. They don't have a supremacy clause in their constitution. All constitutions, be clear, all constitutions in the world do not have that clause where treaties or the supreme law land. But why does the United States Constitution have it? I'm explaining why. The Articles of Confederation, under the Articles of Confederation, there is no court of final decision. There is no supremacy clause. Article 2 of the Articles of Confederation reads, United States, it has United States viz. All 13 states are named. That construction, that legal construction, United States viz, V-I-Z, means namely. All 13 states are named after that. Reserve their rights to be free, sovereign, and independent. And what that means, by contract construction, that each of the states are reserving their rights to be free, sovereign, and independent. You don't have that phrase, that clause in the United States Constitution. You have we the people of the United States, which means, so you have we the people of the United States, which means each of the states are delegating more power. So that's under the principles of federalism. You don't have the principles of federalism under the Articles of Confederation. The Articles of Confederation was drafted in 1777 during wartime. The states did not want to draft, did not want to create a central governing body more powerful than the states. Remember, they're fighting a monarch. They're fighting their mother. They're fighting a monarch. So they did not want to create a central governing body that resembled their mother. They did not want to get. It's not a bunch of dumb men. They're not a bunch of dumb men. This was done deliberately. This was done, remember, it's drafted during wartime, 1777. So they did not have that. They didn't want that in there. But now The war has ended. So now the states are still violating 1784 after the treaty is signed. They're still violating the treaty between Great Britain and the United States. You can't have that. You have war debts. The states are moving slow and sending finance up to pay war debts. So the Articles of Confederation proved that structure cannot exist like that. So John Jay puts out, who's Secretary of State, puts out a proposal to revise the Articles of Confederation. The Constitutional Convention of 1787 is acting on that proposal. They ain't got nothing to do with the Moors. Acting on the proposal of revising the Articles of Confederation. So that the principle. So you have, when the Constitution was signed, during August of 1787, during the Constitutional Convention, the last phase of it, they drafted, not in the Constitution, but it had instructions for ratification, because each state had to ratify. So the delegates of the 13 states left after signing the Constitution with instructions on how to ratify the Constitution, because it had to now be ratified. You have debates with the Federalists and Anti-Federalists. Federalists and Anti-Federalists. The Anti-Federalists are Ku Klux Klan members. The Ku Klux Klan is Anti-Federalist. Anti-Federalists wanted to maintain operation under the Articles of Confederation. That's Anti-Federalist. The Federalists wanted to what? Have the Constitution, be ratified. So you have debates. In 1788, you got ratification debates in all the states. So each of the 12 of the 13 states held ratification conventions. Rhode Island was the only state that did not hold ratification conventions. So based on the principle of quorum, 9 of the states had to ratify it. 9 of the 13 states ratified it. So now it became instant force in 1789. So this is why. So all of the last 3 pages, the United States Supreme Court deliberates heavily on the Supremacy Clause and the state's obligation to treaty. So that's very important. So that's Hauenstein versus Lynham. So there's no going back and forth in this case summary. United States Constitution, Article 5 of the United States Constitution, the Constitution's this, United States Constitution. It's Article 5 of the 1850s treaty between the British Confederation and the United States. Let's go to Society versus New Haven. Society versus New Haven of 1843 and Ware versus Hilton of 1796 are based on the 1783 Definitive Peace Treaty between Great Britain and the United States. And Society versus New Haven, 1843. They heavily reference Article 9 of the treaty between Great Britain and the United States. I think Article 5, it doesn't reference United States Constitution, Article 2 of the United States Constitution, First Amendment of the United States Constitution, Second Amendment of the United States Constitution, doesn't do that. So Keng is right. Keng is right. But I want to give you 3 cases so you can read for yourself, so you can say, according to Society versus New Haven, according to Ware versus Hilton, according to Hauenstein versus Lynham, Keng is correct. You know, when they say Keng is correct, that means nothing. Where's the finding of facts? All right, so Society versus New Haven, Society of the Propagated Faith, Society of the Gospel of the Propagated Faith. That is a religious society that was chartered by Great Britain, by the Crown. And you have New Haven. New Haven's rights were encroached. I mean, the Society of the Propagated Faith rights were encroached. The claim in the case, the defense attorney, the attorney for New Haven made a claim that the Revolutionary War ended pre-Revolutionary War rights. Now, you know that is not, war does not end. War does not extinguish fundamental rights. All right, the 1942, 1491 treaty between the surrendering treaty between King Isabel and Ferdinand and the Bodadel. Muhammad Abu Muhammad, the surrendering treaty that ended Moorish power in Europe. And in that treaty, the Moorish personal rights of November 25th, 1491. I'm gonna make the Chi, all right, to show you that Society versus New Haven principle, that the war does not extinguish pre-revolutionary war rights. That principle is old. All right, that principle is embodied in the 1491 treaty. It preserves Moorish personal rights. It has also extraterritoriality, consular jurisdiction in there. So the war doesn't extinguish fundamental personal rights. So the defense attorney for New Haven, poking his chest out, see, the Revolutionary War extinguished all pre-revolutionary war rights. That's an error. So the Supreme Court ruled that is not so, that the Revolutionary War did not extinguish pre-revolutionary war rights. Now, why does the United States Supreme Court have jurisdiction to hear Society versus New Haven, Ware versus Hilton, and Howenstein versus Lynham? Article 3, Section 2, there's 7 clauses. Article 3, Section 2, and there's 7 clauses of the United States Constitution. The treaty between Great Britain, the 1783, the treaty between Great Britain and the United States does not have an extraterritoriality clause. The 1850 treaty between the Swiss Confederation and the United States does not have an extraterritoriality clause. So therefore, the United States Court has jurisdiction to hear the case. Article 3, Section 2 of the United States Constitution. The United States courts do not have a jurisdiction to hear Moorish cases. United States courts do not have jurisdiction to hear Moorish cases. Why? The 1787 treaty between the United States and Morocco, Article 4, Articles 20 to 25. Those are extraterritorial, compensatory, extraterritorial coastal jurisdiction clauses. Only the Moorish consul has jurisdiction to hear. When a Moor is a defendant, the Moorish consul has jurisdiction, not United States Supreme Court, not United States District Court, not United States courts, not United States District Attorney, not Joe Biden. Only the Moorish consul. Per Article 4, not Abdullah Bay, Articles 20 to 25 of the treaty between Great Britain and the United States. King is correct. That is an error in that motion. But I wanted to give y'all solid finding of facts. So we don't want y'all to say King said, Abdullah said. I gave y'all finding of facts. Peace.
I want to further emphasize, when we're talking about naturalization, immigration, and citizenship, elements that need to exist is what? You give allegiance for that country protection. So what do that mean? What do that mean? I want you to understand, Moors have a vested interest in that treaty, meaning what? It's unremovable. It's permanent. It's fixed. By what? By consanguinity and by consanguinity, just solely, and just sanguinis, and just solely. We have a vested interest. This is why they misclassified us. But if you go to the United States, naturalized, under their position, under their presumption, if you become under immigration or to be a citizen, right, based on the application of law, source of law, what will happen is now the Constitution pertains to you. Now you have a vested interest in that Constitution to enforce those constitutional protections that was supposed to be afforded to you. So understanding the nature of what's going on, based on our inability to be politically legitimized, based on the fraud of misclassifying us, and through this subjugation, the thing that we must do is we must sue to get our rights restored and come together and politically become legitimized. That is the action that must be for the Moors to be made whole again. Failure to do that by listening to misconceptions would allow us to keep remaining alive, keeping alive these misconceptions to continue to go down the wrong path. And we ain't going to be going nowhere but spinning our wheels in place, going nowhere fast because it's too much rooted in misconceptions. I just wanted to add it on to what Abdullah is breaking down and what I already mentioned earlier. When you understand these legal principles, all the BS go out the window. This is why we're doing this, so y'all can have the proper concepts so that we, me, myself, Abdullah, Shim, coming together to teach these classes so everyone can pick up on these things so that we can be sound. Because you ain't going to argue treaty in the same breath argue United States Constitution or any case law. You don't have a vested interest. And if you're going to say that you're a Moor, then say you're a Moor. And then protest all the way through. But there are certain requisites that need to be followed. And if you don't follow them to exercise political legitimacy, we're going to stay in the same condition. Brother Noble, you had your hand up for a while. I didn't seen it. You got something you want to ask or something? Brother Noble, Business Earl, you got a question, brother? So, Amanda, let's go to because it's 6:17. Could we move to the Amanda to the dismissal? There's other motions, but it's 6:17. I don't want to miss that. Could we go into the dismissal and go into that?
Yeah, I have one question. I was trying to turn the mic on, it wouldn't allow me.
Okay,
Can you hear me? Oh, okay. Why are not more of us utilizing the rights of indigenous people along with the Treaty of Peace and Friendship? Because the rights of indigenous people, it solidifies the Treaty of Peace and Friendship. Reading all those rights of us being indigenous and all those rights, which makes us autonomous, it would solidify the Treaty of Peace and Friendship. And I was just wondering why
Okay.
more of us aren't, utilizing those rights.
Let me explain to you why. Okay. The rights of indigenous people is founded in the UN. It's for UN members. Tell me what Moorish member group is a UN member that can enforce that treaty.
So where in the rights of indigenous people does it say that it's for the UN?
We're gonna look at the application of law. Where does that application sit? Where do it sit?
You talking about the rights of indigenous people?
Yes, where do it sit?
With the indigenous tribes.
No. Where was who created such application? Who is the source of its creation?
He doesn't. All right. There we go. There we go. You got it. Now you put the question with clarity.
Who is the source of the creation of such instrument?
You tell me.
The source of law. Where's the source? Based on the application and the construction of this application. This is why I say we got to know these principles. Without none of these principles, we say things that we don't understand. I'm asking you a question, Brother Noble. Where's the source of law coming from?
Who drafted it? What entity drafted it, Noble?
Hold on one second. Somebody's interfering with us speaking. Give me a second.
This is for everybody to ponder on. What entity drafted it?
When was the rights of indigenous people drafted?
No, what entity drafted it? What entity drafted it? Not when. What entity drafted it?
As far as I know, it's all the nations in the United Nations.
Oh, all right.
So I mean, I would think they would be referring to the indigenous people of the land of each country.
But you answered the question. So you answered the question. So the indigenous people didn't draft it. The indigenous people didn't draft it.
Was it not drafted for the indigenous people?
No. Hold on, back. No. So back. Let's get one point clear. So we clear. Let's make sure we clear on King's question.
Okay.
King's question, the source of law. And so I gave clarity on what he means by this. That's a legal principle, source of law. So I explained what he means by source of law, what entity drafted it, not for whom it was drafted, what entity drafted it, not for whom. Let's answer that first. Not for whom, what entity
the UN
drafted it. All right, there we go. All right, go ahead, King.
So if the UN, so when we look at things, we got to look and we got to use the findings of facts to fact check what we're doing. We're trying to argue, okay, if it's drafted by the UN, that is all of those nations, if assisted in any way, they are members. Show me what more entity that's currently a member of the UN now, where they can use such application.
Are you trying to say that we don't have a seat at the UN?
I'm saying, no, I'm asking you a question. What Moorish entity right now in this current state sits at the UN right now?
Do we not have a seat? The seat number 467?
That's in this area right now in the landmass as known today as the United States that sits in that.
All right, King. I want. Let's do this, King. All right. Hey, Brother Noble, Google. So we're not gonna do the back and forth. So I want you to Google right now. This is Google right now, Noble. Members, states of the United Nations. Google that. Like, you don't need to ask King that question. You can find out for yourself. Like, Noble, you don't need to ask King. We don't have member state. You don't need to ask that question to King. You can find the answer for yourself. Google the member states of the United Nations. Like, King doesn't need to answer that. Don't answer that, King. You don't need to answer that. Let Noble answer it. We got it. Critical thinking.
So
No, bro. I'm not answering. No, King. No, brother, please.
I just did what you asked me to do.
All right, so tell me. So you said define. So let me know.
I just did what you asked me to do, and I don't see Morocco nowhere in that list.
All right, there you go. Now we're not talking about the Kingdom of Morocco. We're not talking about the Kingdom of Morocco. You could.
Morocco,
So
period.
you want?
No, it's nowhere on that list.
Well, Morocco's on that list. The Kingdom of Morocco.
Not
The Kingdom of
according to
Morocco's on the
Google,
list.
Member states of the United Nations. I Googled it and I do not see
You
Morocco.
don't see that. You don't see the Kingdom of Morocco.
Nope.
All right. So there's all right. So you don't. So that's your answer.
So we're claiming that we're under the empire.
On the empire, yeah, empire wouldn't include if it Kingdom of Morocco on it. That's not us anyway. So yes, but I'm.
So we need to. I'm trying to get law is very specific. I'm trying to kill these misconceptions so we can stop saying things. We're trying to use and reach applications of a law that don't apply to us because we're not a signatory on such application to be able to use it. We're not bound under that contract.
So the United States doesn't recognize the rights of indigenous people at all.
I never said that. That ain't what I said. I'm saying that we're not a member. We can't use it. Another country can use it, but we can't use it.
That makes no sense.
Abdullah, you want to help me out? I don't understand why it don't make sense. It's just simple common sense. It's common sense. What make you a party to a contract? Brother Noble, what make you a party to a contract?
Signature.
Okay. Show me where the Empire Morocco signed that application, signed that treaty.
Well, according to this, they're not even in the United Nations.
So how could you apply it?
Wow.
What gives you the right to exercise such application?
You're right. I digress.
Okay. This is why I'm saying we got to use findings of facts. We got to understand this stuff on another level. I've been doing this too long, family. You got to show evidence. What's the material evidence? So let's get into here, right? State of Florida in or for Polk County, Florida, state of Florida, case number, division 532024MM005136 A00-BA versus Michael Long, 2639 Bermuda Drive, apartment 102, Brandon, Florida, 33500, right? Agency, FHPL 2024-292950. Charges: imitate Federal Highway Patrol vehicle colors, uniform, and emblem. Notice of noli prosequi. Curtis Griffin, as Assistant State Attorney, give notice that the above style case is hereby terminated and dismissed for the following principal reason, to wit, the facts and evidence will not support prosecution. I want y'all to read this again. Terminate and dismiss for the following principal reasons, to wit, facts and evidence will not support prosecution. I hereby certify that a true copy of the foregoing has been furnished by e-service on the 22nd day of August 2024 to the above named defendant, Curtis Griffin, Assistant State Attorney. When you lay down your claim and you understand how to challenge and deal with the court appropriately, you can win your case based on the following. The prosecution, based on how Mike laid out the claim. We did a class. What class was that, Abdullah? This 6. Was that 4 where we did the motions? We were just, these are some other motions.
Class 4. That's class 4. This is part 2. This is class session 6. That was class 4. It's on the Moroccan Post Media YouTube page. It has
So,
over 500 views so far.
so based on those motions, if y'all want to see there was rules filed, they would not prosecute based on what the actions Mike took to lay down his claim. Anybody got any questions?
Yeah, I got one.
Okay.
So, okay, I just learned something new today, concerning the so-called rights of indigenous people. So we are indigenous, being
Yeah.
Moor,
Right.
in this country, which is our country, because we're supposed to be the de jure and they're the de facto, right? Okay.
When you say this country, what do you mean? You say in this country. You say in this country. What do you mean?
I'm talking about land mass.
Oh, you said all right. So country does refer to land, but we want to make sure clear the layer
Land mass.
because United States is millions of people worldwide. All right, this is for clarity. Millions of people worldwide refer to United States as a country. I said millions. I just stated a fact.
Okay.
Millions of people worldwide refer to United States as a country. So they'll say, my country. I'm going to the country, United States. I said millions of people. So we know
the United States is a corporation.
brother. I said millions of people worldwide.
Right.
So when somebody from Spain or China watches this, so someone from China watches this, somebody from Finland, Iceland, Greenland, South Africa watches this. We want to make it very clear when you say this country, we don't want somebody from South Africa, Greenland, Germany to misconstrue that you're talking about the United States.
But give them the distinctions.
That's all I'm saying, brother. That's it. That's all I'm saying.
So give them the distinctions so they'll know.
All right. This land that's known to the world because of European social engineering, European reconstruction of geography, world history. This land that's on the maps, referred to on current world maps as North America, Central America, South America. That is the actual Moroccan Empire. So when you say this land, so because the Moroccan Empire has been temporarily collapsed, disintegrated, dismembered, we have to recover. We have to restore her. We have to recover our lost Moorish sovereignty. So, United States operating as a trustee, but I want we're going. I don't want to go make your point. I don't want because that's another lesson. That's another lesson.
So,
go ahead.
So that would be North. So that would be North, South, Central America, and the surrounding islands. Correct.
Yes.
Correct. Okay.
So we have to understand this because I know it's hard to hear some of the stuff that I'm saying because you learned it. You study these things with other groups and other people, and they indoctrinated you with these misconceptions. And I understand some of us been doing this for a long time, and it's your life work. Abdullah was doing it for 25 years. Shim opened up a light bulb. Then I further came in with certain information that strengthened everything that he was learning. And now we're more well-rounded together than apart. So this is why I talk about principles of law, so you don't get stuff confused. When we talk about source of law, application of law, operation of law, rule of law, findings of facts, all of these things are embedded into the infrastructure. These things are the DNA. The principle of law is the DNA of the legal system. It helped construct the whole legal system, family. You have
So
to
when
take this in.
so we want to be clear, when King says legal system, he doesn't mean the court system. So when King says legal system, because of when people hear legal system, when the general public hears legal system, they will associate it with court system. Only court system. Let me explain. There are 5 legal systems, major legal systems in the world. Common law legal system, civil law legal system, mixed law legal system mixed with common law and civil law legal system, religious law legal system, and customary law legal system. Those are legal systems, not court systems. Legal systems, not a court system. A court system, a court is a component of a legal system. It's not the legal system. It's not the legal system. It's a component of a legal system. So I just wanted to provide clarity every time. We'll have to say it about 1,000 times. All right, because it's been indoctrinated. Legal system, court system, legal system. That is improper.
That's improper. And that's what I'm saying. Me and Abdullah is here to kill that. So now we can show, like, this is evidence. Mike put this together based on some information he retained from me, right? And he got him a win. This is not by accident or by fluke. This is about understanding how everything is going. When you understand this, you can show and prove. This is one by accident. Abdullah had discussed with me, Mike discussed with me I gave Mike my personal knowledge, broke some stuff down, right? Mike understood, put some things together, showed some things, and this is the outcome when you understand the principles. Now you can get down to business. But when you don't root yourself in these things, right? When you don't know the principles, guess what? You don't have a leg to stand on. And me and Abdullah is coming together and we giving y'all free information. The stuff that we're giving you is on the higher tier of understanding law. This is not the lower level. This is a higher level of understanding. What me and Abdullah have combined forces based on both of our knowledge and experience came together along with Shem, and we're giving you a higher level of law. We're dealing with philosophy of law, right? Theory of law, legal principles, things that you have not heard in the movement. We're showing you application of law, source of law, operation of law, the root that people do not speak about. You have to go to international school, Yale. You'll pay hundreds of thousands of dollars to get this scholarly type of information. What Abdullah has enlightened me, and with the information, and the brother let me tell y'all something. Abdullah is very, very articulated, precise. I wouldn't even be talking to the brother. I wouldn't even waste my time. The brother, I talked to him. He helped me rail around this information. We can do this, y'all, but we got to kill the misconceptions. We got to kill it. We got to kill it. And now we can show, hey, we got better understanding than what y'all thought. We got, here's evidence. we was gonna put something together, put it together, and here's what the outcome was. Show me what other group have done this and showed you this. Broke down the principles, help you understand how to articulate substantive language. Name another group that can show and prove based on what me and Abdullah have put together today. That's
Hey, Ken,
how
you
I'm
want to wrap up?
listen to
It's 6:40. We've gone for 3 hours and 30 minutes. And we started at 3:10. So we're going for 3 hours and 30. We knew we were going to go 3 hours. That was, and I said to Amanda, we may go over, a little bit, maybe about to 6:30.
Can I ask
So,
one more important question? Sorry for interrupting. One more.
Yeah, go ahead. I'm going to say yes. You know that. Go ahead.
Does an affidavit become law after 90 days unrebutted?
Please, King. That's you. Go ahead, King. King,
Does an affidavit become law after 90 days unrebutted?
No. An affidavit is a fact finding.
Go ahead, Bob. Break it down.
It's a supporting instrument that supports the facts in which you lay down your claim based on actual events. Actual events, non-actual. I'm talking about actual circumstances, actual events that can be proven.
So an affidavit reclamation on the record in the public for 90 days and there's no rebut?
No. Let me just say this. If you got a driver's license, you got a social security card, you are getting food stamps, you get Social Security, you are driving on license plates, you got what is that? You got all of these different benefits, right? You got a selective service number, right? Because a lot of y'all do and y'all don't even know y'all do. But you talking about I put an affidavit on the record.
With a protected signature.
With a what?
A protected signature, protecting your signature, which puts you in charge of the contract. That's contract law, right?
Hey, King, man, this is going to, man. Go ahead, King. I mean, because we can't just let it stand. Go ahead, King. You got it, bro. You got to clear it up. You got to clear it up, King. You got to clear it up.
Misconception. First of all, this is why it's a misconception. Let me explain to you. We're gonna go back. Let's understand about how law operates. If you want to talk about operation of law, how do a contract operate? How could you control a contract?
By protecting your signature. All rights reserved, retained without recourse, without prejudice, in brackets. Or the UCC 1-103, UCC 1-207.
Let me ask you this. You come into my house. I say I'm charging you $700 a month for rent.
Mm-hmm.
Right? I already got a contract in place with somebody else. They own it. They own the house. It's not my house. They own the house. They have all the rights to the house. And then I rent you the room. Now, you do a affidavit, put it in the record, mail it to me, right?
Mm-hmm.
Now you saying that you own the house based on the affidavit you constructed, that I got a contract with the owner of the property, that he can show that he has a deed and all of that to the house. Would your affidavit supersede his deed? Supersede his contract with me?
Well, because you said that you're not the original owner, right? You said someone else is the owner, and then you're gonna make a contract. You'd have no right.
So I'm asking you, how you gonna put in an affidavit now that you didn't construct, right? Now you never removed your signature, or you never went through the process of revoking any of the benefits. Where you go to the Social Security Administration, you go to this selective service and physically go through the application for removal and do all of those processes. You just do an affidavit, and you talking about you do a protected signature.
No, you're talking about two different things. That's two different situations. It's two separate, two different actions.
You just
When
said
I brought up,
you just said you put an affidavit in.
I asked about putting in an affidavit. Hold on one second.
I'm telling you, no. If that's
what I asked about the affidavit was.
Hold on. I put in the affidavit saying I'm not a U.S. citizen, but I'm receiving student loan, food stamp, driver's license, and I put in an affidavit saying that and then I'm using UCCs to protect my signature. What do you think gonna happen?
Well, first of all, in order, and what I would do as far as letting them know that I'm not a U.S. citizen, it's in law that we're not U.S. citizens. Dred Scott lost his case.
I'm asking you a question. What do you? Because you elaborating on things. I'm just trying to get you to understand contract, simple basics in contract law.
Okay, but I said one thing about an affidavit, and then I said another thing about signature and protecting my rights, right?
Okay, so you put in an affidavit, but you got a contract still out there. Let's do another example. Let's say you rent a car. Okay, you got a contract, you signed it, all of this. Now you're gonna put in an affidavit that you don't owe them no money. And you protect your signature. They take you to court, and you say they didn't rebut this affidavit. What you think don't stand? The contract or your affidavit?
Well, there's a lot that goes with that question that you're asking. Because first of all, there's no money, right?
Listen to what I'm saying. Listen. Y'all listen to me, man. Y'all get too I know where y'all go with this.
I'm just being practical.
No, it ain't. Listen, the Constitution only identified gold and silver coins as money. But in the relationship that the United States had with Federal Reserve, and the contracts associated with that, at this present time, is used as what?
Oh, a fiat?
It's used for what? What's it used for?
But King, how does that have to do with once again, let's go back to example though. He has a contract, he rented a car. Let's stay on that though. He's rented a car, he threw something else in. He rented a car. He rented a car.
I don't know how he got to rent the car.
Let's stay on that. So he has a contract.
This is the original question. He said he put in an affidavit.
I know, but you gave an example though. You gave an example about his renting a key strike. What I'm saying is he's responding to the example you gave though. You gave an example of his renting a car from a car rental service. Signs it, he rents a car. He drives off the lot. He puts in an affidavit. Check the signature that he don't owe them no finance. So he keeps the car. He keeps the car. He's going to go to jail. He keeps the car and say he doesn't owe them any finance. So he keeps the car, 10 days, 20 days, and they send him a letter, you know what I mean? And he puts a claim in that he doesn't owe them anything.
Why would you do that after the fact though? When you should protect your signature from the start?
The initial question was, does an affidavit after 90 days unrebutted stand as fact? The answer was no.
Right.
That's it. The answer was no. Now, King, if you want to prove your claim on it, I think that's where the confusion came in, but the question got answered.
Well,
It's no.
what the findings of facts is that they're going to use the contract to show that you have an obligation under contract. We talking about contract law, right? You never mention that you're arguing the elements of the contract to show that you've done what? Completed the contract or serviced the contract according to United States laws or any other applicable law under the context of the contract. That ain't what you said. You said I put in an affidavit. And without the understanding that when you sign contracts and there are laws like the UCCs, if the contract identifies that it incorporates the UCCs, and now you can incorporate the UCCs as a remedy, but you must follow the contract to adhere to the discharge of the obligation based on the law that instructed you. You had the legal application to do such exercise. Without understanding the operation of law, you won't know how to do this.
Right.
That's why y'all put in affidavits and they don't work.
Okay, so when you sign a contract and you just sign your name, do you just sign your name or do you protect your signature as above, so below? Meaning, above your signature, you put in brackets, all rights reserved, retained without recourse, without prejudice, or you can put in UCC 1-103, UCC 1-207, UCC 1-308 in brackets above your signature and at the bottom of the page. That protects you and puts you in charge of the contract, correct? Never sign anything without protecting the signature.
Listen to me. That has some implication, but law is very specific. Law is very specific.
Does that not put you in charge of the contract?
So this is what, hold on, listen to me. This is what happens.
Hey, brother, just give him the floor. Brother Noble, please. Please, Brother Noble.
I tell brothers all the time, what rights did you reserve? Show me where you reserve certain rights. This is why I talk about the 1-308 and all of that reservation of rights. Show me where you have filed certain records, and I ain't gonna talk about all of this over the line, where you had those rights reserved, where they known or should have known because it was in the database.
Under the UCC 1-103 and the UCC 1-207 and the UCC 1-308?
I'm asking you a question. Where did you reserve the rights you're talking about? Because they gotta know, they gotta be able to find the rights you're talking about. Or you ain't gonna be able to enforce no rights. How you gonna say I reserve some rights that they don't know exist?
When you reserve your rights on a contract, you reserve all right to change the contract any way you want to.
Listen, where is that at? Where you got it somewhere in writing that you have such right to reserve? And
they contract law.
So hold on. So you and I have a contract, brother. All right, hold on. You and I, Noble, you and I have a contract. You and I iron out the terms and conditions of the contract. So I'm asking the question. So you're saying that you can change the terms and conditions of the contract without consulting me on your own. You can change the terms and conditions of the contract without consulting me.
If I protected my signature, yes. And if you signed your name and you did not protect your signature, they have a right to change the contract without you knowing because they put it in there in small print. It's on contracts. Everything in small print.
I have a question
on
that statement. On that statement, you said you have a right to change the contract. So
if you protect the signature,
without consulting me,
you protected your signature. I got a question. Who's the surety of the contract? Who's the surety?
Elaborate.
Who's the person that's making sure that they're backing what you're putting down? Who's the surety?
That's what's called a surety.
I'm the surety.
So if you're the surety, who's the debtor in the contract?
The person I'd be doing the contract with would be the debtor.
No, you will be the debtor of the contract. You're also the surety of the contract. Now, they don't tell you that in specific terms, but let's say you do know that. There's a violation of any contract when the debtor changes, or if, let's say, one person changes the aspect of the contract without the surety knowing it. If the surety doesn't know it and the surety is not, in the room or on the conversation when it's being changed, then that's a violation of the contract, and you allow them to get out of that contract null and void. You allow them to get out of that contract ab initio. Have you established yourself as the surety? I understand what UCC1 is and all of that, but have you established yourself as the surety, and have you established your straw as the debtor, and who is the creditor in that same contract? If you make
I never put myself as the debtor.
Okay, but if you have to be the debtor because somebody has to sign the contract. Who's the beneficiary of the contract if you're the surety? If you're the surety of the contract, who's the beneficiary of the contract? That would have to be your debtor. That would have to be your straw person.
Okay.
At any time that contract changes, if that contract changes without the surety have knowledge of it, then that contract is null and void. And that's from any side. So if you decide under UCC1, whatever the case may be, that you are in control of the contract and you make any changes to that contract without letting the other party know, the contract is void ab initio. You can't make changes to the contract. A lot of us don't know that. So we go do things like get cars and all that, not understanding that we are the surety and the debtor.
And they make the changes.
Right, and they violate the contract. If they give you an extension on your payment, they've just made a change to the contract. If that was done without the surety and you understand the concept of how that's all being played out, you can get out of that contract because they did it without surety consent.
And that's what we need to get our people to understand.
Right, that's true. But you can't do the same thing either. You can't make a change in the contract without letting the other party know what's going on just by putting the UCC on there saying, I control the contract. That's not how that works. Uniform Commercial Code is a code. It's not law. It's part of policy of commerce. In the policy of commerce that exists, in the policy or as far as law is concerned, that can be changed because it's a code. It's not a law. And I rest on that.
So let me elaborate. Let me break this down about trust law real quick. I'm gonna make this real short. We're gonna talk about things that I know a lot of y'all haven't heard because I deal in trust law. We're gonna talk about manufacturing, bonds, stuff like that, manufacturing agreement, warehouse agreements, distribution agreements, rights, reservation of rights. All of these things go into a trust. You can create a trust, who can warehouse, who can hold the documents, things, who can distribute these documents, who has a best, because once you create the document, a bond, you have a permanent fixed interest in that property. This is why I talk about all of these different things that y'all talk about, these commercial practices. We're gonna talk about law. What makes something law? Me and you can create a contract. Once that contract, we acknowledge it, now it's lawful. It can be enforced. It went through the legal process, changed over to a lawful process. Why? Because both of us signed it.
Right.
Now it's enforceable. It has the force of law. Because you got acknowledgement of it. You known or should have known. You understand the application in which you utilize. Now, when creating bonds that's backed by substance, because the Constitution only recognizes gold and silver. So the only bonds you should have is gold and silver bonds that is deposited into the Treasury, that's utilized through contracts, because they the obligor, they're bankrupt. I can break this down backwards and forwards. You only can reserve your rights where there's evidence of reservation. That you got proof of your claim by perfecting it through perfection of service and understanding how the law operates. We're dealing with operation of law. I'm telling y'all, I know these principles like the back of my hand. Abdullah can tell you this. If you don't understand these things, you're going to go in there and lose. Because you ain't understanding findings of facts. Because once an affidavit is submitted with the supporting memorandum and the exhibits showing the transactions in which that they did not challenge or rebut, now the court has to look at the circumstances and make a legal analysis or determination based on the facts that are now presented before them. I know what I'm doing, family. I know what I'm doing. And I stand with Abdullah because I know what he know what he's doing. So
Hey,
when we
King,
did
we
the first operation of law. So I'm done, Abdullah.
Yeah, we're going, no more questions. No more questions. That's it. All right. So Amanda, thank you for steering us today.
You're welcome.
All right.
Thank
So
you,
it's,
Amanda. Thank you,
Amanda,
Amanda.
it's 4 hours, man. It's been 4 hours now. In fact, Amanda's been on it for like 3. I think she got on about 2:40, 2:45. So Amanda's been like almost 3.5 hours. All right, because she got on, before we all got on. All right. So I mean, I'm sorry, I'm sorry, Amanda. I don't want to cheapen it. Not
Thank
3,
you.
4.
4 hours.
Thank you.
Almost
Thank you,
4.5.
Amanda.
Almost 4.5 hours. So we're going to end. This has been a great class. Thank you, Brother Michael Longs Bay, for allowing us to use your case. Once again, this is using legal principles to draft motions and pleadings, part 2. This will be available between tonight or tomorrow. I will say tomorrow. King Terrence may have it available tonight, but I will say tomorrow on the Moroccan Post Media YouTube page. That's on the Moroccan Post Media YouTube page. All other 5 classes, as well as the Moorish Treaty Protection and Consular Relations course, as well as others. You can share, post any of the classes. You can share, post, let other people know any of the classes. There's no restriction. There's no restriction on any of the classes. All right. So once again, Brother King, thank you. Thank you, Brother Viserius, for reading. Brother Israel for doing the presentation. Brother, who else read? Brother Noble, you read. Brother Rashid read. So thank y'all for reading. Greatly appreciate all of y'all. All right, so until next time, Moorish Monday. Viserius. Brother Viserius want to give us a little tidbit on Moorish Monday.
Yes, sir. Moorish Monday, we're going to be talking about time never was when man was not. And we're going to get into the aspect of how time began, or how time started to be recorded, and who was the ones recording it. We're also going to get into how that aspect of time affects what the nations use as part of their economy, by looking into an organization called the NIST, and it's the National Institute of Instruments and Technology. So we will be getting into all of that on Moorish Monday. I hope to see all of y'all there.
All right, so that's Moorish Monday with Abdullah Iltale Mosipe on Magnet Pyramid Crystal YouTube. That's Moorish Monday with Abdullah Iltale Mosipe on Magnet Pyramid Crystal YouTube page. My special guest for Monday, this coming Monday, is Vicarious Ill. This is his fourth time, I think fourth time on the platform. All right, so I'm excited. I had Brother Inky last week. This past Monday, and I had Brother Vicarious. Brother Vicarious was on 2 weeks ago. Was it 3 weeks ago, I believe? All right, 3 or 4 weeks ago.
Yeah.
Yes. So I'm excited. This brother, I've known him for over 20 years. I also have my my assistant. This is one of my former assistant, brother Yahya Abdul Malik, one of my former etymology, ride and die. All right, known me for over 25 years, etymology class at Temple University, Pan-African Studies Community Education Program, Temple University. I'm assistant for a long time, ride and die. All right. So I want to thank y'all. Peace, everyone. Thank y'all for your support. All right, till Monday, Moorish Monday with Abdullah Iltali Mosebe on Magnet Pyramid Crystal YouTube page, 7 p.m. Eastern Standard Time. Peace, everyone.
Peace.
It's love.
Peace.
Ashe.